Be your mention for liquidation matter up to notice.
Writ appeal of 2018, appellants claiming for regularization of their services were dismissed.
My lord, I am challenging possession notice, my lord. The bank is going to take possession of the minor property, my lord.
Give it to the
Criminal office custody for more than 9 years. And another ballot for hearing, appellant custody for more than 17 years. How did it appeal, Malad?
Pardon to mention, my lord, this is a fresh admission matter on land acquisition.
Fresh matter, filed bank only taken possession. The BAT is pending. Taken up, so then
cases will come.
Fresh admission land acquisition.
My lord, criminal appeal matter, my lord. Petitioner earlier on interim bail, my lord. Thereafter surrender, my lord, kindly taken up.
Surrender what you want.
I am for a hearing of fresh bail matter, my lord.
You have filed a fresh bill.
My lord. Bail is pending, my lord.
Okay.
Item 56. This matter your lordship has heard already, but we were supposed to complete our statements. Like we have to record our statements.
We are taking up first the fresh admission matter. So thereafter.
item 17. And can we on down is not Jenna and I will
70.
17. 1 second.
Why are you making mention?
Mr. Jenna, I hospital.
What is it coming for the first time? No other order passed yet? All right, a mention is made on behalf of item number 17. Mr.
Your
Paresh
lordship.
Chandra Jana, that these may be adjourned for a week with this matter. Yes, ma'am.
Your lordship, land acquisition matter. After.
କାମ ଚାଲିଛି ତଳରେ ସମୟରେ କରିଦଉଛନ୍ତି ତାକୁ ମନା କରାଇଛି ବେଶୀ ତ ଚାଲିଛି ବନ୍ଦ କରାଇଛି
Before submission, advance my lord and senior my lord, item 1. Lordship pursuant to order dated 21/10/24, directed to take instruction whether the advertisement is valid or not. So I select list. So I pray till next Monday. I have not instruction last. Twice notice issued on 4/11 also. I pray for Monday only.
Merit list to obtain instruction as to whether there is any recruitment to group D post in the Justice of Balasore after 21/7/2013.
Yes.
Because 11 years have passed. So that much of information.
That's all. That twice notice issued. I pray for Monday. Right. 4/11 also notice letter was issued.
Mr. G.P. Jana, Land Counsel for the is present. A mention is made on behalf of the Land Counsel for the state. Mr. Aravinda Mahat, Additional Standing Counsel, to raise this matter on coming Monday to obtain instruction as per the order dated 21/10/2024. Is this matter on 18th November 2020? Yes. Incorrectly typed out the sponsor instead of regarding correction of it. Who did you pull it?
Sir, number 23/24.
Manual लिखी देवे रेड पिन करेक्शन पर बेटा कितने नंबर होगा
Year टा change है.
441
And the year टा change है. 23 जगह 24 है. Year टा change. 23 जगह 24 है. जी ना.
4 is 4 out and then let's go.
12, 11.
Upload कर देना.
Okay.
Item number 2.
Therefore, Mr. Mahanti, I am permitted to place him at the article. When I received, I am challenging the order of the government that my land has been exempted without giving opportunity of hearing or a notice. And even if they are not supplied the region of exemption or on what ground my land has been exempted by the Annex 1, there is no plot. Plots.
Resumed means how is it resumed? Was it granted to you
Yes, madam.
and has been resumed back?
The information has not been supplied.
No. The land which you are occupying was a grant by the government.
Yes, madam.
Is it?
Yes, madam.
Kindly read your writ.
I am purchased from the list.
Then you read the writ, sir. Only 4 paragraphs are there. 4 or 5 paragraphs. Kindly read.
Yes, madam. Para 3 mentioned
Yes, the brief fact. Yes.
the case not said that petitioner since the forefather occupying the scheduled land in question without any obstruction from any converter, while the matter stood thus as a land as recorded in the name of Ratnakar Prasad Dev, son of late Vipin Vihari Dev, and after his demise, the petitioner and his family members are in possession of the same since long.
So what is the manner in which you are occupying? It was a land of the government. You occupied it. And later you said that it was recorded in your name, according to your assertion. Then, para 4.
In the name of your father, it was recorded. That is your
I am the legal heir.
Forefather, sir.
I am the legal heir successor and filing the death certificate.
All right. 3, 4, and 5. What is 5?
That Ratnakar Singh was the son of Dindayal Singh and subsequently adopted Vipin Vihari Dev. And since then, he is known as Ratnakar Prasad Dev, on whose name the land was recorded under Khata number 260, Moja Ambogaon, District Devagad, and another Khata 165, Moja Ambogaon, District Devagad. Annex 2. But while the matter, Ratnakar Singh, the father of the person, was expired on 2/1/2022, leaving behind his 4 sons and 1 daughter. So when that is prescribed to the opposite party government, we are the legal heir and successor of Ratnakar Dev.
So it was taken to the government land.
I am assuming, but they have never supplied any information.
No information was given to you, but it was recorded in the name of government. How can it be taken here?
Recorded in the name of the government, but this.
So you have to establish your right over the land. You need to declare yourself to be the owner of it. It's required declaratory.
Whether a mere entry in the ROR would substantiate that you are the owner of that land.
Ratnakar Prasad Dev, my
Adoption is there, many things.
here is the here of Ratnakar Prasad Dev. The land is recorded in name of my father.
You are not coming to the main thing. It is a government land and it has been given on lease, as you say, to Mr. X. From Mr. X, your forefather purchased. So where is the document to that effect?
That's I'm only when the land was. I am not finding any plot in that plot. I am issuing advocate notice to supply the regions for what the land had been exemption, but they have not never supplied.
The question that has been put to you, the question of resumption comes only once somebody has been given on lease and he fails to carry out the order of the government in utilizing that land in a proper manner. Suppose it is given for agricultural purpose, he fails to use it, the government may resume it. So where is those documents so that your name can be recorded there? And moreover, if it is a case of resumption, then alternative remedy is available to you.
Whereas printing the region, but they have not registered.
Page 13 make a glass. Page 13. এই খাতারে প্লট উপলব্ধ ନାହିଁ. And that means that prior to his purchase, land was sold to others.
No. I have.
There is no proper pleading. There is no information in the writ petition, and the nature of land and the nature of relief you are claiming cannot be granted in a writ.
Then I maybe give some times. I will give all these records to the writ petition and amend the same.
Counsel for the petitioner seeks permission of this court withdraw the writ
No,
application,
no,
file a
I'm
better one.
amending the
Sorry, file a better one. We are giving you liberty. Disposed of as withdrawn. Yes.
Item number 3.
Please also, they require some time to take instruction last occasion. Letter was issued.
Mr. Mansi was there earlier.
Your Lordship, I'm appearing on behalf of Mr. Ratha. He's unwell tonight, so kindly grant a short adjournment.
You are mentioning on whose behalf?
Mr. Rath.
Mr. Ratha,
Acha.
petitioner.
Senior. Let it come Monday.
It's in high.
Whether the vacancy caused due to non-joining of has been
government
marked in
That's
the next advertisement.
Next advertisement issued.
That
Next.
vacancy merged with the.
That is exactly.
That is what the instruction was. Because that is the rule. That is that.
ଆପଣ ଗୋଟେ page ର affidavit file
ଆଜ୍ଞା।
କରିପାରିବେ?
ଆଉ ଚିଠି ଯାଇଛି next Monday ଥାଉ ଆଜ୍ଞା।
1 ଅଗଷ୍ଟରେ ଆପଣ order ଟା pass
ଆଜ୍ଞା ଆଜ୍ଞା I am gone through that's why there. Monday. Letter was communicated but no instruction. I play Monday.
Land Council for the state, Mr. Arvind Mahanti, Additional Standing Counsel, 6 week time to obtain instruction as per the order dated 1/8/2024. The mention is made also on behalf of Mr. Prafullo Kumar Roth, Senior Advocate, to adjourn the matter. Mr. P.K. Mahanti and Senior Advocate is present for opposite party number. This matter will be commencing from 25th November 2024. Hala? File that affidavit that it has been filed.
28th May.
25 ତାରିଖ ଦିନ ଆସିବ।
Hello.
Item 4.
For your lordship.
4. The pursuant to the order of the Honorable Court, the state council are directed to go through the document in the sealed cover before the registered judicial.
Order dated 23rd,
25.
23/9/2024, your lordship, may I have a glance.
Now we have given you permission.
That maybe I may be allowed someday to today have to.
We have allowed more.
And I have not come. So that I cannot assist your lordship. No, nothing is there.
So do it to the order is already there.
Only there, that.
The Land Council for the state, Mr. Govinda Mahanti SC, submits that as per the order dated 23/9/2024, though he has been permitted to verify the file, verify the original file concerning GA plot number 159 unit 3 Bhubaneswar, but he has not yet verified, and he'll verify it by next week. The matter will be taken up a week after. Mr. Siddharth Mishra and counsel for the petitioner is present. This matter is commencing from
Basing on, I have relied on the squarely covered matter, my lord.
So let him go through it.
My lord, another 2 orders, I have supplied the copy of those orders. My friend may be directed to obtain instruction whether those orders have been carried out or not by the G department.
Do not know where is those. You
That,
have not filed those orders.
Before
Have you filed
another
those orders?
order, my lord, I have produced on the first
No.
date of hearing.
It is not.
This is not on record. You would produce it by the orders produced by a memo or something like that.
My
You can pass some order that you will verify. You are giving it, it's all right. Yes, this matter will come on 25th of November.
Can it be on 18th, my lord? 25th, I will be absent.
No,
18th.
you will verify by next week. So there are 3 days holidays are there. So just to verify and that
27th, your lordship may pick. Because on 25th, I will be absent.
27th will be there.
27th of 27th. Yes.
Item 5.
My lord, the And for the borrower, last occasion, Lordship directed to serve the copy of the writ petition. They have not served the copy.
Lords, we had served it on Mr. C.DASH. He refused to take it, saying, and my lords, notice has not been issued. My lords, the dispute is between us and the opposite party number 1, the collector, because he has to take possession and give it to us. Kindly wait.
18 and order in last.
You are for whom? You are appealing for
Borrower.
For the borrower, my
Number
lord.
3, for the diagnostic and Pranay Kumar, Mr. Prasant Kumar Satpathy and his associate.
My lords, this is a matter between us and the state. The borrower doesn't come into the picture at the section 14 stage.
What order which passed?
My lords had asked us to file an affidavit whether there's any stay. We have already filed the affidavit, which is already there on record. And my lords, the second thing is they are delaying this matter because
Mr. Counsel, have you received the affidavit which was filed in compliance of our order dated 16/8/2024 by the authorized officer?
My lord, with the permission, I am with along with Mr. P.K. Satpathy, the Baru. My respectful submission before the lordship, they have not served the copy of the affidavit as well as the read petition also, my lord. That is the crux of this.
No.
my lords, the state has
not received, my lord. You let them serve what are the contentions of the read petition they have indicated.
Please look at the list. It's
read petition as well as the
annexure.
The Land Council for the states also, Mr. Sahoo, the Land Council appearing for the opposite party number. You are appearing for whom?
Along with Mr. P.K. Satpathy, my lord. My lord,
In your chari.
my lord.
For Pranay Kumar Mahanti or what?
No, my lord, that's for the Mr. Lal is appeared for him. Sujit Lal. He's the option purchaser.
Mother diagnostic.
Mother diagnosis.
I am appearing mother diagnostic copy number 3.
Have you got you are appearing for this mother diagnostic or what?
My lord, mother diagnostic.
Mother diagnostic medical road Ranihat.
My lord.
Through its proprietor Srimati
Priyadarshini Behera, my lord.
Okay. Appearing for opposite party number 3. Have you received the affidavit copy which has been filed?
No, my lord.
The Land Council for the opposite party number 4. Also the Land Council for the state submits that the affidavit which has been filed by the petitioner in pursuance of the order dated 18/8/2024 has not been served on them. Let the Land Council for the petitioner serve the copies of the affidavit on the respective council along with a copy of the writ petition on the Land Council for the opposite party number 3. During course of this week, matter will be listed in the week commencing from 25th of November 2024. Yes.
Obliged, deeply obliged.
My lords, we had served a copy on the state because we cannot file. Unfortunately, it's not there on my record.
Yes, next item.
Item number 6.
May I please, Lordship? The petitioner challenging the order dated 19/10/2023, Annexure 4, Your Lordship, at page 58, Your Lordship. On page 62, the operative part of the order, Your Lordship. We have considered the rival submission of the respective parties and perused the records since the applicant failed in the LDC in 2006.
No, you took time on the other day that you file a fresh synopsis.
Already.
Have you filed?
Yes.
So where is that synopsis?
After
synopsis flag.
After first.
Okay. What is your prayer in this writ petition?
Challenging the order dated 19/10/2023, passed by the Law and Tribunal, Kotak Bench, Your Lordship, at page 56, 58.
What was your prayer before the Land Tribunal? Come to your paragraph number 1.
Yes, Lordship.
Page number 60.
60, Lordship. 60, sir.
60. That is internal page number 2.
Yes, sir.
Running page is 60.
Yes, Lordship. It
read it out. Why are you not using that Wakam?
Law and Counsel for the respondents. On the other hand,
no.
You come to that Wakam.
Please come here. Oh, he is there to assist you. Why are you not using it? annexure, did you get it?
Yes, sir.
Annexure
4.
4, page number 2.
Page number 2.
Ah,
Yes, sir.
that is running page is 60.
Yes, sir.
So please read it out from that.
According to the applicant,
Yeah.
according to the applicant, the community was appointed as Khalasi on 1996. The respondents that the department conducted limited departmental competitive examination LDC in the year 2004 for filling of the vacancies of skilled artisan grade 2, grade 3 against 25 hours quota. In the year 2005, trade test was conducted for the post of Mason 3 ECR, that is not ECP, that is ECR. ECR 3 and EBS 3, but he was not given any opportunity to appear at the test. By efflux of time, he was granted one financial upgradation. But despite existence of several vacancies in skilled artisan grade 3 under reserve category, he was not allowed any promotion. According to him, he submitted recommendation on 19/1/2016. Thereafter approached the tribunal 2/11 of 2016, which was disposed of on 12/4/2016, with direction to respondents number 4. Without the application, mind rejected his recommendation on 29/6/2016. And hence, he has filed this present instant way with prayer to pause the order dated 29/6/2016 and to direct the respondents consider his case for promotion to skilled artisan grade 3 and grant him more consequences sufficient benefits. Proceed.
So what was passed? Ultimately, what order was passed by the paragraph number 7?
7.
Page 63.
Yes, sir.
Internal page is 5.
5 bits. We have considered the rival submission of the respective parties and perused the records. Since the applicant failed in the LDC in 2004 and in 2006, trade test was not conducted due to surrender of vacancy, and in 2012, he could not be empaneled to appear at the test due to his seniority position and made the representation only 19/1/2016. This way is hit by the law of limitation. No MA has been filed by the applicant seeking condonation of delay. Prayer of the applicant is also found to be vague as is prayer of for retrospective promotion, from which date is conspicuously absent, possibly because with intention to overcome limitation section 21 of the AT Act is very clear insofar as counting of limitation is concerned. Your Lordship, that has been dismissed. Your Lordship. Your Lordship, error is that, Your Lordship, I have made the trade test for the year 2005. They have not taken into consideration the trade test of 2005. In view of the counter affidavit, they have said that has been surrender. But so far,
this how you explain this inordinate delay? You just that you failed in 2004.
5 to 16.
Then you filed just a representation in 2016 after 12 years.
The orally, because it is the group DM.
Orally,
You are saying only turn to page 38. What is the rejection order?
File the representation, then you approve the. So 2004 रे आपण fail कले 2006 रो जो trade test ला you are not included, right? So that you are not conducted because the vacancy was surrendered, and you could not be empaneled also in the 2012. So all these years for 12 years you remain silent. I am not disputing. Then suddenly file a representation and then approach the tribunal. The tribunal has said that you have not filed any application for condoning the delay.
I have not filed, but I have got the information as per the instruction as per the order passed by the department. University. Department know whisper about the limitation. University. And she paid 38. University. After direction of the tribunal,
we have to see. You see on the face of it whether there is any palpable
Yes,
illegality in the.
we are not in appeal.
Yes, sir. Because I
it's not that.
We are not in appeal, sir.
Yes, there is nothing in that order.
They have not. What speaks about the 2005 selection? I have 2005 as the senior.
Sorry, sir. Heard the London Council for the petitioner. We are appealing from the other side.
We are for the approval. For railway, we are appealing. Yes.
Party and Deputy Solicitor General of India, along with D. Guchas. And the writ petitioner, Gyanendranath Behera, who is at present working as technical field under Senior Section Engineer Works, East Coast Railway, Bhubaneswar, has filed this writ petition challenging the order dated 19/10/2023 passed by the London Central Administrative Tribunal, Cuttack Bench in OA number 260/00635 of 2016 in dismissing the original application, both on the ground of limitation, so also on merit. The petitioner uh, case before the London Tribunal was that he belonged to SC community and was appointed as Khalasi on 19/1/1996. And the respondent's department conducted limited departmental competitive examination, LDCE, in the year 2004 for filling of the vacancies of skilled artisan grade 3 against 25% quota. And in the year 2005, trade test was conducted at the post of Mason 3, ECP 3, and EBS 3, but he was not given any opportunity to appear at the test. And by efflux of time, he was granted one financial obligation. But despite existence of several vacancies in the skilled artisan grade 3 under the reserve categories, he was not allowed any promotion. It is the further case of the petitioner that he submitted representation on 19/1/2016, and since that did not he did not get any fruitful result, he approached the London Tribunal in OA number 211 of 2016, which was disposed of with a direction to the senior divisional personnel officer to consider and dispose of the representation. The contention, the case of the petitioner is that the said respondent did not apply his mind properly and rejected his application on 29/6/2016, for which he approached the London Tribunal again by filing OA number, the aforesaid OA number 260/00635 of 2016. His prayer in the OA was to pass the order dated 29/6/2016 with a further direction to the respondent to consider his case for promotion to skilled artisan grade 3 and to grant him all consequential service and financial benefit retrospectively. The respondent entered appearance and filed their counter affidavit, wherein it is stated that the applicant appeared at the LDC 2004 but failed to qualify. And as for the avenue oblique channel of the promotion, a person holding the post of head clerk is to be promoted to the post of technical 3 or trades opted for as per the seniority, subject to passing out the requisite trade test. And trade test was conducted in 2000, technical 3 was conducted in 2005. The applicant opted for the post of technical 3 ECR, but due to surrender of the post under work study, the trade test for the post was not conducted. Thereafter, his junior, Sri Narayan Sarangi, who opted for technical 3 EPS, was found suitable in the test and was promoted. So, as for the rules, the vacancies of technical 3 or test are being filled up on the basis of seniority cum suitability through test. Accordingly, it was stated in the counter affidavit that the claim of the petitioner was not justified. It is further stated in the counter affidavit that option was called for the trade test in the year 2006 for one post of technical 3 feeder, in 2007 for one post of technical 3 FOM, and in the year 2012 for one post of technical 3 feeder, and the applicant opted for the post of technical 3 FOM and feeder, but as for the seniority position, the applicant's name could not be included in the list to appear at the said trace test. After hearing the Land Council for both the parties, the Land Tribunal has been pleased to hold that the petitioner failed in the LDC in 2004 and in 2006 trade test uh, was not conducted due to surrender of vacancy. And in 2012, he could not be empaneled to appear at the test due to his seniority position. Top. It was further held that though he made representation only on 19/1/2016, the original application is hit by law of limitation. No MA was filed by the petitioner seeking for condonation of delay, and the prayer of the petitioner was found to be vague, as is a prayer for retrospective promotion from which date is conspicuously absent, possibly because of his intention to overcome the limitation. And Section 21 of AT Act is very clear insofar as counting the limitation is concerned. The after hearing the Land Council for the petitioner and the Land Deputy Solicitor General of India, Mr. Gochai, and after going through the order passed by the Land Tribunal and the amendments made in this one, so we find no infirmity or illegality in the order of the Land Tribunal. When the cause of action is stated to have arose in the year 2004, and the petitioner remained silent and for the first time made a representation in the year 2016, and thereafter approached the tribunal, he should have explained the delay in a proper manner, which has not been done, and therefore the Land Tribunal is quite justified in passing the impugned order. Accordingly, the petition being devoid of merit stands dismissed. Yes, next.
Item number 8.
Seven for a
କେତେବେଳେ
mention.
ନାଇଁ ତ ମେନସନ କେବେ କିଏ ମେନସନ
Item number 7.
आगुरी ऐसे मेंशन कर दिया होगा कि प्राइवेटली. Yes. Item number 7.
Annexure 2 is under challenge.
Next.
Item number 8.
Surmel.
That the petitioner challenged the order of the Land Tribunal
Central Administrative Tribunal under Annexure 8, madam. So portion of the order with regard to the remaining the matter to the appellate authority with regard to comparison of the loco pilot for lesser punishment, madam. And on the last occasion on 17/9, your lordship wanted to see whether, while considering the appeal, whether any personal hearing
Is
can be
that
made.
in order dated 17/9/24.
Madam.
Have you got that copy of that order?
Yes.
Please come to the paragraph number 6.
Madam. When appeal was preferred by the petitioner, the appellate authority, after going through the inquiry report and the appeal memo, has held that due process of inquiry has been followed and the petitioner has been given sufficient opportunity to prove his innocence, and therefore charges level against the petitioner has been duly proved.
Yes.
So
No,
thereafter,
paragraph 7.
Paragraph 7, Learned Counsel for the petitioner seeks some more time to verify whether there is any provision for giving personal hearing to the petitioner at the time of final disposal of the appeal by the appellate authority, and seeks for an adjournment.
Yes.
In fact, there is an provision for giving the personal hearing, but the appellate authority has not considered that, madam.
Where is that provision? That is
Lordship, on the last occasion, I am giving now. Wait. Was last coup. Special provision for non-gazetted staff, whether the penalty of dismissal, removal, compulsory retirement, reduction or withholding of increment has been imposed, the appellate authority may, at its discretion, and if it is considered necessary, give a non-gazetted railway servant a personal hearing. Assistant loco pilot.
No. Penalty.
Penalty, dismissal.
Dismissal.
That was
come to the punishment part. But punishment has been imposed, paragraph 5 of the said order. You are Porutile 17/9/24. Order.
Appellate authority reduces punishment.
Hence, ALP should be more vigilant
and cautious
that he had observed the
signal aspect as yellow
of A5P10 and passed the signal AS310 in caution. He also observed red aspect and applied emergency brake, but released emergency brake as per LP, but he failed to be extra vigilant, cautious for the aspect of so and so. This was the just observation made. So how it comes within this dismissal,
it is removal, compulsory reduction is there. It is not reduction.
Annexure 4, page 34 for a moment. The punishment order.
Yes, let us come to them. Where is that? DA inquiry was conducted in order to represent so and so.
But a dismissal from railway service.
Yes.
With immediate effect.
I impose.
You have been dismissed.
I dismissal from dismissal against personal hearing दियानी बेली जो कहउछंदी को बेसिस रे कहउछंदी अपन जो सबमिशन कले which of course we have noted down in the paragraph number 6 and 7 of
on the last occasion your lordship wanted to see whether because the appellate authority basing on the inquiry report pass an order.
Where is the order of the appellate authority? Annexure 6.
Yes.
Please come to that.
Annexure 6, madam. Yes.
In the instant case, so and so supposed one, but he was one of the members. So for us, so and so, I understand that the appellate in this case, so and so.
Last full.
Just a minute.
Ma'am.
I have gone through the appeal against the notice, so and so, and the entire case file. As per the case record, the charge memorandum was initiated on the charges and while working in so and so. Subsequent to the major penalty charge stated so and so within imposed funds. I've gone through the same in details, including the inquiry report and your appeal. I find due process of inquiry has been followed and you have been given sufficient opportunity to prove your innocence. After analyzing my mind adequately in the case, I have come to the conclusion that the charges leveled against you, so and also conclusion 2% failed and 4% responsible. So I'm of the view that qualified. Yes, Mr. Padhi, this provision is there that if he's a non-gazetted staff and you are imposing the penalty of dismissal, removal, etc., then he has to be given a personal hearing and the appellate authority. But as it appears from Annexure 6, he has just quoted what he has and he himself verified all these records and came to the conclusion and ultimately disposed of the appeal and confirmed the order.
Yes,
So-
my lord. I also think so. I take instruction, my lord, because this order says something and this annexure 6 is different.
That is the
tribunal has observed that. What I think so, this punishment
Annexure
is
6 is the Mr. Padhi. Annexure 6 is the order which
order of the appellate authority.
subject is the appellate authority's order.
Correct. The
Disposal
next
of your appeal dated so on.
is correct, my lord.
No, here only one thing was to be done. If he did not exercise his discretion, he should have given the reason why a discretion of personal hearing will be dispensed with in this case. How he found this? Because at its discretion,
that is not there also in the order.
My lord, but this is page 39. It was I don't think there is a disposal of the appellate
38, 39.
Page 39.
Yes.
Appeal against the decision of such and such appellate authority, reviewing authority. There is a
That's
scope
all right,
there.
but what is the when the appellate authority's order is suffers from this non-compliance of this 24 rule 24 of this 68 rules. So,
Now I have to examine the revision authority whether file an application with revision authority or not, and what is its outcome.
Sure.
If he not exhausted a forum.
Oh.
All right. The petitioner Jyoti Ranjan Nath, who is he was working. You have been removed from service.
Assistant loco pilot, madam.
Yes. You
Because
were
after accident, 2 persons been died. That's why.
You are working as assistant loco pilot in the office of Chief Loco Pilot, Bhadrak Division, East Coast Railway, Charampa Bhadrak, has filed this writ petition challenging the order dated 8/12/2023, passed by, where is that order?
Annexure 8, madam.
Passed by the London Administrative Central Administrative Tribunal Kotak Branch in OA number 260/00540 of 2018. In
Data number is correct.
Annexure 7.
7.
In what has been who has filed? You have filed this original application.
Madam.
So what is the operative portion of the order?
Page 64.
64.
Yes.
So in remitting the matter to the appellate authority to reconsider imposition of lesser punishment in the light of punishment imposed on the loco pilot by the appellate authority. With a further observation that in such an event, the petitioner shall not be entitled to any back wages from the date of dismissal till his reinstatement, and he will be entitled to notional fixation of his pay. Against this particular order, you approached this court earlier.
No.
Then what is this WPC city number 1
In a similar case, Honorable High Court of Calcutta has stayed. Calcutta, yes.
The London Council for the petitioner submitted that against the order of dismissal from railway service passed by the authority against him, he preferred an appeal on 23/8/2018. And the appellate authority, by order dated 10/8/2018, without giving the opportunity of hearing to him, considered the inquiry report and the appeal memo, and the conclusions on the charges, and came to hold that the punishment imposed was appropriate. Punishment imposed by the disciplinary authority.
Opportunity.
Remand only on the question of sentence. Only on the quantum of punishment. That is the operative follow. Tribunal order large portion page 65.
গলা পরে থাকলে তো অপরচুনিটি দেয়াই নতুন আছে দেখতে বোধ
but it is limited for a limited that imposition of
lesser punishment. No opportunity to be given.
Lesser punishment. The Land Council for the petitioner drew the attention of this court to Rule 24 of the Railway Servants Discipline and Appeal Rules 1968, which provides that where a penalty of dismissal, removal of, compulsory retirement, reduction or withholding of increments has been imposed, the appellate authority may, at its discretion, and if it considers it necessary, give the non-gazetted railway servant a personal hearing before disposing of the appeal. And at the personal hearing, the railway servant may be accompanied, if he so chooses, by another railway servant employed on the same railway administration, office of the railway board, its attached office or subordinate office, as the case may be, in which the appellant was or is working, or an official who is not a legal practitioner bracket ends of a railway trade union recognized by the railway administration on which the appellant was or is employed. The Learning Council for the petitioner submitted that the appellate authority in the order dated 10th August 2018 has not stated that there was no necessity for giving personal hearing to the petitioner. And therefore, the petitioner has been seriously prejudiced. Stop. The Land Council for the Deputy Solicitor General submits that against the order of the appellate authority, there is a provision for review or what? Mr. Padhi?
No, further appellate authority is there. As they have mentioned it in that order itself.
Okay.
Within 45 days.
There is a provision for further appeal, and the appellate authority order is also very clear that the appeal against the said decision lies with PCOM oblique ECOR oblique BBS bracket revising authority within a period of 45 days from the date of receipt of the notice. Mr. Padhi, Learning Deputy Solicitor General, seeks time to obtain instruction as to whether the petitioner has approached the revising authority or not, and if so, what is the result of the said appeal. Put up this matter. When, please tell Mr. Padhi.
10 days time, man. 10 days.
Okay, 10 days time. Place this matter in the week commencing from 2nd December 2024.
Obliged. Mr. Gochait is appearing with
Mr. We have already.
Item 9.
In this item 9, the union with the petitioner.
Yes, sir.
We have challenged the order of the Central Office Tribunal.
Which order, Mr. Padhi?
The order that under Annexure 3, page 85.
So, what was his prayer as for paragraph number 1? Let us see.
But what it is a case which is related from Bibisar Das. I have noted that he has taken time for amendment, so I may give some time to check it out.
Yes, taken
time. Say noted his file 39 2024. He written that general filing amendment.
No,
change
amendment କଥା କିଛି ଲେଖା ହେଇନି ଖାଲି ଲେଖା ହେଇଛି adjournment ଆଉ ତାपर order ଲେଖା ହେଇଛି ଯେ you made a submission that he has now become the AGA, so he will
I will check it up and let me know after 10 days.
The Mr. P.K. Padhi, Learning Deputy Solicitor General of India, 6 1 week time to verify whether there is any necessity of amendment to this petition or not. Put up this matter in the week commencing from 25th November 2024. Kahana dekhiwa?
Yes, ma'am.
Kahana dekhiwa?
I am SS Kashyap.
SS Kashyap.
Yes.
All right. The name of Mr. Bimbisar Das shall not be reflected in the cause list henceforth.
Item number 10.
My lord, item 10, Annexure 3. This and the union is a petitioner. And I'm just briefing my lord.
Yes.
We are agreeing with the order of the Learned Tribunal in respect whether this particular portion I am just reading, that is in page 124. It starts from 123 para 11 mile.
Yes.
No, sir, but 123 para 11.
Yes, sir.
Besides the above, it is not a place. Sorry, it is not a it is not a place to not out of place to mention that according to the respondents department, the CBI case is instituted against the applicant on 12/11/2008, but there was no progress till 6/1/2014 for near about more than 5 years, and on 6/1/2014, the criminal case was stayed by the Honorable High Court of Calcutta only for a period of 5 weeks. Thus, there was no progress from 12/11/2008 till the date of promotion order was issued in favor of the juniors of the applicant on 13/12/2013. Even till the date of CBI case is still pending without any order of stay by any higher forum. At the stage, it is relevant put up for the record that the Honorable High Court of Orissa for the delay of conclusion of the criminal cases directed the promote to applicant giving effect for accommodation of the DPC entitling him to all consequential benefits till the case of Nihar Ranjan Chaudhary versus State of Odisha, W. Such and such, and Odisha State of Odisha versus Ashok Kumar Hota, W. Such and such. Then Mr. Malay Kumar Pradhan, State of Odisha, such and such, and disposal such and thus, as they discussed above, this being one such case, by applying law laid down in the above cases, the applicant is also entitled to relief claimed in this way. Then, my lord, thus, view of from the any angle discussed above, the tribunal is not find any justification is keeping the recommendation of the DPC, finding the applicant fit under a deemed sealed cover, we can giving promotion to juniors. According to the impugned order of rejection communicated by fellow such and such, dated such and is hereby 12th March 2021 is hereby quashed. Since the applicant was already been found fit and DPC of the respondents is directed to promote such and such. I am just highlighting, my lord, for this tribunal has referred the Harsh Kumar case. Our point is that the Harsh Kumar case is not applicable to this case because this delay part is concerned in the Harsh Kumar case. The state is responsible for the same. Here, the applicant is file application for the Calcutta High Court got stay order.
But
It
that
is not
was
the
only
delay
for
part, only 6 days, my lord.
Mr. Padhi, that was only for 5 weeks. That stay order there.
That is for 5 weeks.
Yes.
It is for 5 weeks. We have got the 6 days time only.
No,
So,
it is the
number one.
The case was instituted in 2008 November, and
he was considered in 31/12/2013. 2013.
So at least by that time, there was no stay order because the stay order
there is no stay order in Calcutta High Court. But prior to that, I am just enlightened my court. Against the order of he has filed this issue a seal cover order. He has filed a way that is 856 of 2014 on 1/12/2014 before the Central Tribunal, that is way number 856. That way was disposed of on 1/12/2014, madam. Considering the reprehension. We consider the reprehension, rejected the apprehension. Then he preferred another way, that is 1/6/2015. And that way was also disposed on 8/4/2015. It was not disposed of. Against the said order, again he filed another way, that is 4/3/2015. That was disposed on merits. After disposal the same order, that was dismissed, and against which he has preferred the writ petition before the High Court. Honorable High Court remanded back that this authority concerned will consider, that is, I am just for a moment, let's come to the page 68. Page 68. It start from page 67, WPC number 14922 2020.
68.
Page 68. I am going to the crux of the paragraph. Para 6.
Yes.
In view of the above facts and circumstances, this court disposed the writ petition with a direction to the opposite parties to hold the department promotion committee in term of the observation made by the apex court in the case of Harsh Kumar Sharma, IFS versus State of Punjab and others, reported in 2017, Volume 4, SEC 366, and thereafter taken consequential steps in accordance with law. The Hosmer judgment also annexed by us, that is in annexer page 53.
53.
Page 53. Lordship got it?
Yes.
This in that judgment, Honorable Apex Court has given some guidelines as to the next paragraph. The authority is required to consider the following aspects: A, B, C, D. The D is relevant to us. Whether the delay in finalization of the proceedings, departmental or in the court of law, is not directly or indirectly attributed to the government servant concerned. Here is a case, then let's may come to the E, whether there is any likelihood to misuse of official position which the government servant may occupy after ad hoc promotion, which may adversely affect the conduct of the departmental case and such and such. Then we have considered his case. Consider a case basing on the, you may see the page 44. It is page 44. Page 44. Let's see page 44. Page 16. Sorry, page 69. Sorry, page 69. 69. 69. That is the impugned order which was quashed by the tribunal.
12th March 21.
Is 12 March 21. That's correct. Then in this order, we have considered the Hosmer judgment. We have gone to the guideline of the Supreme Court and passed necessary order. Then also this event also may come to the page 74, paragraph 8. Let's got it, paragraph 8. Yes. In that paragraph, we have to, whereas the keeping the above facts of the above facts in view of the case of Justice A.K. Patnaik was examined in the light of the DUPT guidelines quoted in the para 4 above, and department came to a following conclusion. Then further the promotion, we have expect categorically the basing on the Hosmer judgment, the authority has passed the order based on the direction of the High Court. And this order was challenged by the petitioner before the tribunal. Tribunal neither distinguished about this Hosmer judgment in any manner, and taking into consideration of the High Court order, we have passed the order simply for the same for which we are my lord. The previous writ petition and the present writ petition filed by us, that was filed by the petitioner. Present, we have filed this.
So the question is that whether that delay occurred.
Yes. Was attributed to the authority
in that CBI proceeding, whether it is attributable to the this opposite party or not.
That is before consideration of the promotion matter. It is 2008.
And the proceeding, as has been stated, it was instituted in 2008. And we do not know when the charge sheet was submitted or whatever it may be. So it was simply instituted, and the promotion aspect came in the year 2000.
Lordship knows it, for a promotion aspect, without the clearance from the TBC, we can't proceed, because if anything will clearance will not come, we can proceed with the promotion. when came to know that case is pending, we kept the sealed cover against which come to tribunal.
Yeah.
Prior to that, against the CBI proceeding, he is approved to the Calcutta High Court. So this is the issue. My humble submission to my lord is that severally he has approached the court, and an order was passed by the direction of the Honorable High Court of Orissa. Her score of judgment is taken into consideration. Here is not applicable to the case of the petition.
So, what is the present status of that CBI proceeding?
That I have to take instruction out of this.
Because if it was instituted in 2008, so 16.
But the person concerned has got retirement in 2015.
15.
2015.
So
you are claiming that I have to get all retributive promotion, all these steps. Here is a clear-cut issue that we have kept in sealed cover, and it was well known to him that case is pending.
Only he has to just get the financial benefit retrospectively. That was the order passed by the.
Then only.
Only that. He has retired. Right. The Union of India has challenged the order passed by the London Central Administrative Tribunal dated 5/3/2024 in OA number 402 of 2021, which was filed by the opposite party, Amiyo Kanti Patnaik, who was in the meantime retired as Deputy Commissioner in the Office of the Chief Commissioner GST, Central Excise and Custom, Bhubaneswar. From the impugned order, it appears that a criminal case was instituted against the opposite party on 12/11/2008, and there was no progress till 6/1/2014. And on 6/1/2014, the criminal case was stayed by the Honorable High Court of Kolkata for a period of 5 weeks, whereafter the stay order was vacated. And from 2014 till 2024, there was no progress in the CBI case. The London Counsel for the Union of India, Mr. Deputy Solicitor General, placed the impugned order of the London Central Administrative Tribunal, particularly paragraph number 11 and 12. Wherein the tribunal has been pleased to hold that there was no progress from 12/11/2008 till the promotion order was issued in favor of the juniors of the applicants on 31/12/2013. And except the stay order for a limited period, there was no contribution from the side of the opposite party to the delay in the result of the CBI case. Accordingly, the London Tribunal has been pleased to hold that there was no justification in keeping the recommendation of DPC finding that the appellant is fit under deemed sealed cover when promotion has been given to his juniors. The tribunal ultimately held that the directed the respondents to promote the opposite party to the post of Joint Commissioner of Central Excise and Custom with effect from the date which his juniors was promoted by the order dated 31/12/2013 and grant him all consequential service and financial benefit retrospectively within a period of 60 days. The Land Council for the petitioner, Union of India, submitted that the Land Tribunal has placed reliance in the cases of Nihar Ranjan Chaudhary versus State of Odisha, reported in so State of Odisha versus Ashok Kumar Avtar, Dr. Marav Kumar Pradhan versus State of Odisha, so. However, the ratio laid down in the said case is not applicable to the present case, and therefore the Land Tribunal was not justified in passing the interim order. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. The requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Put up this matter.
Sorry to interrupt.
After court, you are entering appearance.
I wish to
Mr. Swan, so I shall let you go. Issue notice to this one, so Mr.
We'll file a miscase for stay of the impugned. That is IR number 10590.
Just a minute.
Till then.
Mr. Jagmohan Patnaik and his associates have entered appearance for the opposite party. Let a copy of the writ petition be served on the Land Council by next week. Put up this matter in the week commencing from, so let it come in the week commencing from 16th of December 2024, 4 weeks time you are ready. You file your counter affidavit, if any. IA number so and so, issue notice on the interim application. So what order is necessary? There is any, if the stay order is not passed, how you will be affected? It is only a direction so and so. So to consider so and so. So issue notice on the interim application. The petitioner counsel is at liberty to file his objection to the interim application also. Yes, next.
Item 11.
Yeah, please. The petitioner before your lordship is an auction purchaser. He challenges the proceeding before the DRT instituted by the loanee as being not maintainable. A few dates are important. On 25th of June 2023.
Which order is under challenge?
I am challenging the proceeding before the DRT, that saying that the same is not maintainable.
Proceeding has been initiated at the behest of the borrower.
Borrower, yes. A few dates are important. On 25th of June 2023, a auction sale notice was published.
Which is appearing for the other side.
Notices, bank, I believe, has appeared, but notices on the borrower has not been sent.
Mr. Naik, you are appearing for whom?
For the state, my lords, Collector Koraput.
So when that section 14 SARFAESI proceeding was initiated?
That has been initiated, it has been concluded, orders have been passed, but the orders are not being carried out. That is one of my grievance.
No,
That is the second limb of
want to know that when that final order was passed.
the final order was passed on.
And
That
what
is
was
annexure.
what was that order? Two things. When that order was passed and what is that order?
Page 13 of the brief.
You have annexed that order.
Yes.
That is extract. Huh?
Okay.
Page 13. Annexure 1.
Please read it out. So,
the case is taken up today. The additional government pleader is present. The petitioner come authorized officer, Union of India, Koraput is present on call. The opposite party is absent on call. Perused the case record and found that a loan amount of so-and-so is outstanding with the opposite party on so-and-so who had taken that loan by mortgaging the land and building white khata number so-and-so on on an extent of 14 decimals under Moja Koraput Nagar of Koraput Tehsil. In meanwhile, auction has already been undertaken by the bank authority, but the bank authority could not take possession of the property of so-and-so. The Tehsildar Koraput is directed to hand over possession of the auction property to bank within a week and report compliance.
who are you?
I'm the auction purchaser.
Then, so this order was passed on 16/11/2023. Right.
Now kindly take the next page. What does the Tehsildar do? The Tehsildar, without giving me possession, he says that he gives a notice to the person, borrower, take notice that you are hereby directed to vacate the building which is situated on so and so on or before 18/1/24 as per order passed in SARFAESI case of District Magistrate Collector Koraput, failing which you will be evicted with application of force on 19/1/24. But he doesn't do anything.
So the this particular two orders that which you just now placed,
yes,
that is challenged by the
no, that is not challenged. He has challenged the action taken by the bank under SARFAESI.
Okay.
13 section 13 action.
But is there any stay or anything?
There is a stay passed by the tribunal.
Oh.
So you have already entered appearance.
I have entered appearance. I have asked, prayed for vacating that order. That matter is being posted from day to day.
What is the order sheet of the that?
The entire order sheet has come to your lordships, I believe. Your lordship on the last date had directed that the order sheet be provided. It has come. I have also
SA number is listed so and so for hearing. The copy of the last order dated so and so is enclosed for kind. Further, it is submitted that certified copy of the entire order sheet of the case was applied and deficit court fee was deposited on thereafter so and so certified copies has been issued. Okay. And
I have procured the certified copies in the meantime, but I believe the tribunal has also transmitted.
No, that is not.
No, that
only
is
just
I have the certified copy, your lordship must see. Now, if your lordship takes page 3 of that document which I have just handed over, it shows the order sheet begins on 11/8/23.
Just
at page 3. That is the day on which the proceeding begins. Now, my contention is that on this day, this proceeding could not have been entertained. Because the time for this proceeding had gone by then. To assail an auction under section 13 on 11/8/23 was not available.
That time was 45 days.
No, the time was till an action under section 13(8)
that is there.
Is undertaken.
That is there, yes.
And once an action under section...
In that 13(8) is issued, that means resumption proceeding can't be there. That will...
And here in this case, in July 2023, sale certificate has been issued.
July 2023.
Yes. The date is 27/7/2023.
So Aji challenge this particular order which you are now uh, showing to us. This
No, he has not challenged this order. He has not challenged this order. He has challenged the action under section 13, saying that the bank has wrongly taken action under section 13, 13.4.
What order was passed in that? Any stay order?
Stay order is not possible.
Order
The
is
stay.
written,
The stay was granted. He was called upon to make the deposit. He has made the deposit in question, and the stay has been granted. On
and you have also entered appearance.
I have
that
entered appearance in October 2023. I have prayed for alleging that the proceeding is not maintainable, vacate. 1/2/24.
October 23.
17/1/24 stay granted.
Non-counsel for the respondent bank present. Non-counsel for the applicant submits that the applicant is ready. No, but resumption.
17.
Oh, he has proceeded with the resumption proceeding after 13.8.
So I have challenged two things in this writ petition. One is that the proceeding itself is not maintainable. And secondly, the authorities under section 14 have not acted in terms of the statute, in terms of the mandate of the statute. And if your lordship sees the order sheet,
it just come to the order dated 17/1.
yes, that is page 17, it is there.
Yeah. This was on the stay of auction. This petition was
By that time, auction, sales certificate, everything has been over.
That is exactly. So, what is your, if you are appearing in that proceeding much prior?
I am not being heard at all. I am not being heard. Even when I appear in court, it is recorded in the order sheet that I am not there.
No. Stay application was filed. The copy of the stay application must have been served on you. And when it was considered on 17/1/2024, it is simply mentioned that the learned counsel for the applicant is present, learned counsel for the respondent bank is present. So you are not present on that day. And nobody brought to the notice of this court that such an order has already been passed by that on 16/11/2023 by the collector Koraput. So where are you when you have received the?
All these things are recorded in my objection, which was filed in October 2023. All these things.
It's all right, but Mr.
I was very much present. My client was very much present in the tribunal. His presence is not being recorded.
It's from the order itself.
No, his presence is not being recorded in the order sheet.
Now, how can we say that on 7?
I'm not on that. I'm not on that. I'm on the question that the tribunal could not, the bank, it was the obligation of the bank, because it was on the bank's application that section 14 orders were passed. So it was the obligation of the bank to bring it to the notice of the tribunal that the proceeding itself is not maintainable. They did not do it. I did it. Even then, the tribunal goes on to pass this order.
It seems that the bank has also not brought to the or not raised any contention on that day. That at their instance, this petition has been filed. And
the bank is now sitting pretty with my money and the borrower's money.
It's all right. So
it's a win-win situation for them.
You are for the bank.
No, he's not.
He's for the bank.
Lordship has to issue notice.
Notice has not gone, my lord. The private opposite party as it is the bank. Notice has to go.
Somebody was there for the bank on the last occasion, but today I moved. And Mr. Udgata here, he appears for the petition, the borrower in the tribunal.
He is there to watch you only.
The moment
section 18 is there, but he can also
appeal before the DRT. If any order is proceeding is not going to without jurisdiction.
No.
It is
Proceeding
he has already he is successful man.
Yes.
So he must have invested huge money,
Yes.
and that is also with the bank.
Interesting, yes. The particular essay has been challenged. The auction has been challenged on the ground that the auction notice has been published against a dead person. So itself it is wrong. It is void under law. So when it will not stand, auction notice will not stand itself. Automatically entire thing will go. Auction notice will also cannot be say that I am a valid purchaser. So everything will be decided by the DRT.
Now he is the auction purchaser. He has got a favorable order from the that in the 14. In spite of that, he is unable to
because when the
because a stay order was passed and all the things were not brought to the notice of
the stay order was subject to the entire liability and the
By whom?
By the borrower.
How? After 13.8? After 13.8?
Because DRT found that the auction notice itself is void under law because it has been published against a dead person.
Who has said this?
Prime official.
You see, the data in 17/1/2024, it has been mentioned that in the above facts and circumstances, the applicant, since he is ready to deposit the total outstanding dues and already deposited so and so to show his bona fide, therefore the respondent is directed not to proceed further till the next date, and the appellant is directed to submit the DD after revalidation within 7 days from today's onward. So by this time, this order was passed on 17/1/2024. As Mr. Mukherjee has read out those two orders, one by that the collector, which was passed on 16/11/2023, and the next order, which was passed by the Tahsildar, that was on 4/1/24.
Issuing a notice to vacate. Issuing a notice to vacate as an abandoned precaution.
When Section 17 proceedings pending before the DRT, on the question of the mentality of that auction.
So in 17/1/24 notice, whatever you are submitting doesn't find place. That it is on the ground of the auction being the notice to the public and against a dead person. Nothing has been mentioned.
But lots of can find. I don't know. I have not been solved with any read petition. The main ground in the essay.
You intend to appear for whom?
I am not appearing because there is notice. I am just sitting. I just came to know that.
No, it's all right. So you are appearing for whom? Appear. Borrower means D.
All the three.
All the three.
All the three.
Land
4, 5.
You also may not because you also said notice.
I said that he has instruction.
No, I have no instruction.
For to appear for opposite. No, we are mentioning all those things. 4, 5, and 6. Let the Mr. Mukherjee let a copy of the writ petition be served.
With permission, with permission,
yes.
Let notice to go because
we are mentioning just this writ petition has been filed. This we mentioned prior to that. This writ petition has been filed by the petitioner, Udla Satish, challenging with a prayer to pass the essay number 146 of 2023, pending before the Land and Debts Recovery Tribunal, and for a direction to the opposite parties, number 1, 2, 3, to hand over the possession of the auction property to the petitioner. It is the submission of Mr. Gautam Mukherjee, senior advocate, that the petitioner was the auction purchaser and he participated in the e-auction sale on 13/7/2023, and thereafter he was declared as the H1 bidder, and he being the successful bidder.
Sales certificate was issued on 27th. deposited the bid amount before the bank, and
Sales certificate on 27/7.
and the sales certificate was issued in his favor on
27/7/23.
27/7/2023. Since the possession of the property in question was not handed over to him, as it was in the possession of the borrowers, who are the opposite parties number 4 to 6, the uh, bank filed a petition, an application under section 14 of the SARFAESI Act before the DM and collector Korapur, which was registered as SARFAESI case number 5 of 2023. And in the said case, the collector has been pleased to order by order dated 16/11/2023 to the Tahsildar to hand over the possession of the auction property to the bank within a week and report compliance. However, according to Mr. Mukherjee, instead of handing over the possession of the auction property, the Tahsildar issued notice to the opposite party number
3.
Opposite party number
Govind Raja.
Govind Raja. That is 4.
4.
Opposite party number 4, Govind Raju, to
Vacate. Give vacate.
secure responses on to vacate the building and to honor before 18/1/2024, failing which you'll be evicted with application of force on 19/1/2024. The Land Council for the petitioner further submits that the borrowers opposite parties number 4 to 6 have filed SA number 146 of 2023, in which notice was issued to the petitioners, so also to the bank, and they have entered appearance, and the petitioners have filed the show cause for that is the order dated today.
17/1/20.
An interim application was filed by IN number 119 of 2023 to stay the auction. The petitioner has also filed objection to the interim application, and when the indicating the subsequent developments made, however, the learning tribunal passed an order on 17/1/2024 in the said interim application.
It's IA number 1149 of 23.
IA number 1149. What order was passed? The operating quarter.
That is page 17.
Page 17. The order was passed, staying with the stay order. Which will the applicant to pay the difference. First of all, the fact that ready and already
Interim order to continue to.
The bank was since the opposite parties number 4 to 6 deposited an amount of rupees 15,20,000 Therefore, the respondent bank was directed not to proceed further till the next day, and the opposite parties, number 4 to 6, were directed to submit the PD after devalidation within 7 days. The contention of the Land Council for the petitioner that since the uh, uh, as per the auction sale notice, sale certificate has already been issued, and in favor of the petitioners, and the collector has taken steps under section 14 of the SARFAESI Act, and all those matters were brought to the notice of the Laden DRC in the essay number 146 of 2023. There was the essay, the order passed by the Laden DRT on 17/1/2024 was not justified. He further submits that the essay as such is not maintainable in view of the development made.
Amended section 13 to amended section 13(8) of the SARFAESI Act.
In view of the section 13(8), na?
Yes.
In view of section 13(8) of the SARFAESI Act, and particularly in view of the
Rule 9(2) and 9(6) of the security enforcement.
And view of the decision of that.
That is salary. That is that
110 point के तो उड़ावे चला.
the reference is AIR 2023 Supreme Court page 4568. Celir LLP versus Bafna Motors.
Celir LLP. Issue notice on the question of admission indicating therein that matter shall be disclosed of at the stage of admission. State you Mr. Gosratal and counsel submits that he has instruction to appear.
I have no instruction. You notice to the party.
Sorry. Well, problem.
Yeah.
Issue notice on the question of admission so and so, and will dispose of requisites for issuance of notice on the opposite parties shall be filed by
Friday. I'll find.
By Monday, after Friday is holiday. So by 18th of November 2024, the Land Council for the state accepts notice on behalf of the opposite party number 1. There is no requirement to issue notice to opposite party number 2. The matter will be listed in the week commencing from 16th of December 2024. What further you want, Mr. Mukherjee?
Let the proceedings, let the DRT now states and
Because the matter has been changed to 19th of this month, pillars. It is finally to be disposed of pillars. As you also previous pillars, it can be also disposed of pillars.
no, he does not have any instruction. Let him.
When my
The order sheet is there.
You have no issue. Either you appear to say that your instruction, or so that.
You also issue notice.
So that's why we are doing that. Yes. So till the next date, the further proceeding in SN number so on so shall remain state. That is your prayer.
Yes.
In that IN number 13676 of 24 or what?
12169
12169
of 2024.
All right. Next.
Oblate.
Item 12.
So files the order sheet of the SA number so on so which is taken on
Madam, item 12 And again, I'm troubling my lord. And Mr. Sanjeev Sai also joined in the state panel yesterday. So let's keep it to some other day and make it arrangement.
Mr. Subhranshu Mahanti and counsel for the petitioner is present. And Mr. The learned Deputy Solicitor General Mr. Padi submits that the case was entrusted to Mr. Sanjeev Swain, learned senior panel counsel, but he has he is now become the additional government advocate. Therefore, somebody else has to be entrusted this case, and the matter may be taken off a week after court.
Yes, ma'am. Yes,
This matter we commence from 25th November 2024. ठीक तो? हाँ.
Item 13.
Please use the mic properly. What order we have passed earlier? And you have received the report on the Tahsildar dated passport order date and filed the same on court. So you have filed that copy.
My lords, that memo is filed, my lords. It's there with my lords.
Query is made to the land council for the petition about the status of the land pertaining to so and so. Constructed as a house.
The status report, my lords, has been filed with a memo. It's there in the court records.
It appears that the lease in question has been granted for agricultural purpose, but the land
He
has
could
not.
not find out the place. That is, there is no
been-
status report. The report says that we are unable to locate the plot.
एवढा status report जो office of the
आगे,
तहसीलदार
आगे.
होता है.
Notice has been issued on 4/11/24 to the petitioner to remain present
Hmm.
and cooperate with the RI Chandaka so that the land can be, exact location of the suit land can be located. It's a 52-acre land. So he has not been able
कौन
to.
हला 4 एकर कौन हला?
Notice मते पाई.
पेपर लिखा है जी अपन को.
से जो
ये
notice
कॉपी डाची तो अपन बारे.
आगे आगे.
तो
से को दिन तार बेते ना.
ଏଇଟା କଣ ଆପଣ ପାଖକୁ ମାନେ ଏଇଟା କୋଉଠୁ ପାଇଲେ ଆପଣ ତାହେଲେ?
I have given a copy.
Lordship have direction.
I have filed.
କେବେ ପାଇଲେ?
Last
କହିଲେନି ତାଙ୍କୁ ଯାଇ appeal କରିଥାନ୍ତେ ସେ spot ରେ present 4 ଏକର ଲେଖା ହେଇଛି.
6/11 I have furnished a copy. My lord may fix a date. With the consent of the council, he may appear and.
So fix another date so that
Again, my
if he
lord.
was not present.
My lord.
So the land council for the state has produced the letter dated 25/10/2024 of the Tahsildar Bhubaneswar, wherein it is indicated that as the suit land is extended over a vast area of approximately acre 52.470 decimal and is covered with the structures, and the remaining area is lying vacant, the exact location of the plot of the petitioner could be located only in the presence of the petitioner, and accordingly notice was issued to the petitioner to remain present along with the documents on the spot on 4/11/2024 and to cooperate the RI Chandoka to locate the exact location of the suit land. The copy of the RI report has been annexed to the letter dated 25/10/2024. The London Council for the petitioner submitted that the petitioner has not received any notice from Tahsildar Bhubaneswar to remain present on the spot on 4/11/2024. However, he submits that if another notice is issued giving a sufficient time to the petitioner will definitely remain present at the spot and cooperate with the RI to locate the exact location spot along with the documents, exact location of the suit land. Land additional government advocate Mr. Nayak submits that a fresh notice will be issued to the petitioner fixing another date and the matter may be adjourned.
My lord.
to some other. Release this matter in the second week of December 2024. The Learning Council for both the parties shall apprise this court about the development made in the time.
Lordship, in second week, I have some personal problem because of
Third week,
marriage.
tell us.
34th.
16th of December 2024. Yes.
Item 14.
First occasion was directed to the statement with the one lease over there.
Just a minute, Mr. Swanso. Just. In view of Learned Council for the submitted the Learned ADM Bhuvnesh. Inter alia, classification of land in the Sabi Karobar is Kuchila Vana, which means that it was forest land, but the Tahsildar also was mentioned in the order sheet that the classification has been changed from Kuchila Vana to Puratana Patito by mutation proceeding. For this one, so the Tahsildar is not competent to sanction the forest land without obtaining NOC from government land. In this connection, it is the contention of the Land Council for the petitioner that there is nothing in the Forest Conservation Act that Kochilavana comes within the forest land. State Council seeks some time to obtain instruction in that respect. So on, so is okay.
I haven't yet received those instructions. I prefer some more time because I'll update those instructions.
Land Council for the state submits that as per the order dated 28/10/2024 is yet to receive the instruction and therefore the matter may be taken up 2 weeks after. Place this matter in the week commencing from 2nd of December 2020. Yes.
Item 15.
Yes, the petition has to file the case against the rejecting order of the Central Administrative Tribunal.
Just Mr.
Well, and in this case, we have already matter of dismissal, already received the Paraj's comment. We'll file the counter within 2 weeks.
Mr. S. Nandi, Land Council is present for the petitioner. Mr. P.K. Padi and Deputy Solicitor General appearing for the Union of India with
along with Mr. D. Sahoo, Dilip Sahoo.
Central Government Council submits that Parawai's comment has been received and within 2 weeks counter affidavit will be filed and the matter may be taken up thereafter. Matter to be listed in the week commencing from 9th of December 2024. The council is at liberty to file the presenter affidavit if any after receipt of the counter affidavit.
Item 16.
9 तारिख आपन से 2 सप्ताह भीतर काउंटर एफिडेविट देबे यदि आपन रिजल्ट चाहउछनी फाइल कर देबे 9 तारिख आसीबो फाइनल ये पन डिस्पोजल. Yes.
May please lordship. In this case, the issue was before this court whether the order or rule 10 petition is applicable to reference mallet. That matter mallet.
Please wait. This writ petition has been filed by the petitioner challenging the order dated so and so of the Land and Civil Judge Senior Division Sundargarh in so and so. In the impugned order, Land Court has been pleased to take note of the ratio let down by the Supreme Court in case of so and so, wherein it has been held that a person who has not made an application before the land acquisition officer for making a reference under section so and so cannot get himself impleaded directly before the reference court. Land Council for the petitioner or that the division bench of this court in the case of so and so has been pleased to take note of the decision of the Honorable Supreme Court in case of so and a similar case remitted matter to the land and so to hear the petitioner on the order one to retain afresh and implead the petitioners in that writ petition then as parties to the LA reference case. LA reference can to pass appropriate order by affording opportunity of hearing to them along with other claimants for just and proper adjudication of the case for apportionment of the compensation amount among this one. However, after going to the judgment in the case of Swanso, it appeared that the subsequent decision passed by the Honorable Supreme Court in case of Swanso and has not been taken into account, wherein it has been held in clear terms that a party cannot directly apply in the reference court without approaching the land acquisition officer earlier. It also seemed that the division bench has not considered the ratio laid down by the Honorable Apex Court in Ram Prakash Agrawal Sukha, which has been referred to by Swanso. Six next time to examine the decision which has been done. Yes, sir.
May I please read? This issue with regard to applicability of order or rule 10 petition as considered in Ajmalingam case in arising out of section 18 proceeding, my lord. And this so far the issue in Ramprakash Agrawal case, that is in respect of to setting aside the award passed in absence of a person who is not a party before the Supreme Court. That both the judgments are distinguishable for fact of the present case, and they are not on a different context. The same judgment has been decided.
No, you are relying on a.
My lord, I am relying, my lord,
you are relying on a division bench decision of this court,
right? My
lord. Which has relied upon the that 95 Supreme Court
that decided by judgment of 3 judges bench, and Ajmalingam case decided by the 2 judges bench of the Honorable Apex Court. My lord, this specific.
What about the this Ram Prakash Agrawal?
Ram Prakash Agrawal case, my lord, the issue before the Honorable Apex Court that the order has been passed in absence of the that Ram Prakash, and that, my lord, I am bringing the specific issue with regard to maintainability of the order rule 10 petition.
Hand over him so that he will study and.
I am handing over. Your lordship.
Hand over so that he will prepare.
And government.
Not that. Mr. Nayak,
my lord,
you have got the copy of that order with you, 28 and 24,
my lord,
right?
My lord.
And you go through these decisions. You have to go to 4 decisions which have been referred.
My lord.
One is that Ram Prakash Agrawal, 2013 Supreme Court, SCC. Second is that the order which was placed by him, that is January 9, right?
My lord.
Third is that Navy Lignite Corporation Limited case, 95 Supreme Court. And the fourth one is that Azam Lingana case, right?
My lord, I have examined Ram Prakash Agrawal case as well as the Azam Lingana case. That Ram Prakash Agrawal case as well as Azam Lingana case, in that case, the reference was under section 18 of the Land Acquisition Act. My lord, but I am from the impugned order, it is reflect that the reference is under section 30 of the Land Acquisition. 30 with regard to apportionment of the my lord. In support of the petition,
there it was meant. You see, in that what has been held in that Ram Prakash Agrawala case,
my lord,
we have quoted also in that paragraph number 3,
my lord,
that a person who has not made an application before the land acquisition officer for making a reference either under section 18 or 30 of the land acquisition of cannot get himself. So it covers both. It's not that only.
That made clear last time.
Made clear. So
that may I reply, my lord. That question was raised when the expert award has been passed and a person came for filing an order 9 rule 13.
Observation is very clear. It is not that it is totally foreign.
That
it relates to that. And suppose you cannot say that the court was not deciding in the land acquisition matter. It is total out of context. And such a sweeping observation has been made. So that is why it has. That cannot be said.
I am submitting.
Deciding land acquisition matter. The court was deciding at what stage a party can be impeded directly or not. So that in that context, the observation has been made that it may be either under section 18 or 30 of the Land Acquisition Act. So he cannot make directly be pleaded in the reference court. He has to make an application and his case is to be reported. That's simply thing.
Here is the
My lord,
case is section 30.
I am submitting, my lord. The doubt in the mind of the court, I am clarifying, my lord. This issue was raised before the Andhra Pradesh High Court after passing of the Ramprakash Agrawal and Ajmalingam case. The issue referred to the 5 judges bench of the Andhra Pradesh High Court, my lord. And I have filed the judgment that Repka case page 17, my lord.
Go through it.
What happened when the daughters filed the order 1 10 petition and that has been rejected? Thereafter, the parties made compromise and take back the money.
We are rightly from the beginning, we are telling you that you are not remediless. That proceeding is still pending. You can just file an application.
No, my lord. That's not permissible. That's not permissible. Remediless, no, my lord. If the application
once you cannot be impeded there, and you are supposed to file your application before the collector so that it can be referred to the so how do you say that you are remedial?
The observation your lordship suggest me on the basis of observation made in the Ramprakash Agrawal. The Ramprakash Agrawal suggestion has been made since the award has been confirmed and the reference code has already decided.
Section 30 is not there.
Not there.
Section 30 is not there.
Not there, my lord.
How it is mentioned right now?
Why, my lord, section 30 they have incorporated. The section 18 proceeding they have converted to section 30. Therefore, the Honorable Supreme Court says by allowing implement, the scope of reference is increased. That was the subject matter in Ramprakash Agrawal case. And the remedialist observation is made. If the award has been expert award has been passed, the person has the scope of filing separate.
Why you are avoiding that? Why you are avoiding to go for reference?
Since the award, the reference case is at the end, now compromise petition has been filed between the brothers, and they will conclude that.
Not you cannot by
time which you are consuming before.
Yes.
By
this time it would have
if the law permit and the reference code, that was the observation of the
Andhra Pradesh. It is decided the much water will be flown on.
Therefore I am insisting for stable.
Go and take immediate steps, and if you withdraw it and say that we will approach, we can direct to consider it and make necessary reference in accordance with law, which is to be adjudicated along with the already case pending. That would subserve your purpose. So instead of wasting your time here,
I am not
asking us to decide this all these matter which has already been decided.
One point, my lord, I will point out that Andhra Pradesh High Court. Thereafter, since this is a question of law, the Andhra Pradesh High Court page 17 of my judgment. That has been
counsel for the you have given what you have given some citations or what?
Citation, note of submission, which citation?
For the petitioner has filed a note of submission along with some citations, right? Which are taken on record. Copy of the same has been handed over to Mr. Naik, then an additional government advocate in court. He seeks some time to go through them. Matter will be listed in the week commencing from 25th November 2024.
So far they stay,
Sorry.
Otherwise they will. One, I want page 26 again 26 time
item number 18.
17.
Supreme Court also adopted that, my lord.
Item 18.
17, so 18 could have. Yeah.
Item 18.
May I plead the lordship? My lord, I have come with a limited prayer, my lord.
Yeah.
The account of the petitioner declared NPA, my lord. Thereafter, he wrote to the bank, my lord, to provide the details of the outstanding. They are not giving him the details. Only prayer is your lordship may kindly direct allow me the courts, the bank should allow me to sell my property and pay the entire amount.
That was that way. What notice has been issued? 13-4?
Annexure 1. No, my lord. Issued by the collector, my lord.
13-4 has not come.
That is not with me, my lord. They have not served on me, my lord.
Your Lordship,
Annexure
I
1 I have challenged.
to appear on behalf of bank.
Yeah.
Opposite party 1 to 4.
What is your instruction in this matter? What has been done in this case? As we find that the 13 to notice was issued so and so this come to this annexure 1 which is dated 27/12/23. Then
Your Lordship, we don't have the petition.
I will serve a copy, my lord.
DCB bank is what? Of a private bank, I suppose.
Your Lordship, section 14 has
DCB is a private bank?
Yes, my lord.
yes, please come to that annexure 7 series. 7 series रे से जो लेटर टी आपण एटा किए देइछन्ती आपण एटा कार लेटर
7 series
एटा बैंक रो लेटर
आरंभ होची बैंक रो
हां देखंतु paragraph 2 को आसंतु
मिलर
by the district magistrate collector Puri. So 14 stage has already is already over. So and as per the government so and so you have mentioned so and so DRT has considered your case for settlement. It may be noted that there is no specific order from the honorable DRT to our bank. Further, your request in granting some more time is denied upfront so and so. So the stage is already over. We
Yes,
cannot entertain the repetition here.
Only,
So,
my lord, I am ready to pay the entire amount. I may be
approach the
allowed.
appropriate forum.
I have approached, but they are not, my lord, supplying me the details of the outstanding.
Your matter is pending before the DRT.
DRT, my
appears.
lord.
What is the number of that case?
Number of the case is, my
Have
lord.
you mentioned here?
No, my lord. OA number 401
Why
of
is not mentioned? When you have already approved the alternative forum.
Yes.
And
no, bank has approached.
That is in session over the matter.
Bank has approved. 14 is already over.
Bank has approached. I have not approached.
14 is already over. So,
Yes.
So the order must have been in favor of that auction purchaser. And you must have been directed to vacate it immediately.
No, auction has not taken place.
Huh?
Auction has not taken place.
No. 14 has already been completed.
14 stage exam
No, my lord.
14 district magistrate ko order
They have directed me to hand over the property.
that is what. No. Therefore, the Tahsildar cum executive magistrate people is directed to take over possession of the. This is the DM's order.
District magistrate
14 ସରିଗଲାଣି
ତାଙ୍କର ସେଲ୍ ସାର୍ଟିଫିକେଟ ଇସ୍ୟୁ ହେଲା ପରେ ଯେହେତୁ ପଜେସନ ନବାର ଅସୁବିଧା ହେଲା ତାପରେ ବ୍ୟାଙ୍କ ଆପ୍ରୋଚ କଲା କଲେକ୍ଟରଙ୍କୁ ଆପ୍ଲିକେସନ ଦେଇକି 14 ରେ ଯେ ପଜେସନ ଦିଆଯାଉ ବୋଲି
ସେଇଥିରେ ତହସିଲଦାର ଆପଣଙ୍କୁ ନୋଟିସ ଦେଇଛନ୍ତି ଭ୍ୟାକେଟ କର
ଆଜ୍ଞା
କୋଉଠି ଯାଇ ପହଞ୍ଚିଲାଣି ଷ୍ଟେଜ ଆପଣ ଫାଇଲ କରିଛନ୍ତି ବୋଧେ ସେ proceeding ku challenge karikini SARFAESI proceeding 13(4) ku challenge karthile. Then what is that number? OA number?
OA number is, my lord, 401 of 2023.
401 of 2023.
Miller.
It is pending achi.
It is pending achi.
Art the Land and Council for the petitioner and council for the state. The petitioner has filed this writ petition with a prayer for a direction to pass the order dated 27/12/2023 passed by the district magistrate collector Puri. Date ta dekhibe 23/12/2023 na in directing the Tahsildar from executive magistrate PPL to take over possession of the property and to hand over the same to the security creditor, that is DCB Bank Limited. Land Council for the petitioner submits that against the order passed by the DCB Bank, authorized officer DCB Bank, under section 13(4) of the SARFAESI Act, the petitioner has already approached the land DRT cutter in OA number 401 of 2023.
Sorry, my lord, the bank has approached.
Bank has approached. Bank, the bank has approached the 13-4 notice of Fatima that relating to this matter is sub judice before the DRT in OA number 01/2020, which has been filed by the Disciplinary Act. You have already entered appearance.
Entered appearance.
And the petitioner has already entered appearance in the said case. Since the one of the party has already approached the uh, uh, appropriate authority and the petitioner has entered appearance, any relief sought for can be appropriate application can be filed in said proceedings for necessary relief. Therefore, we are not inclined to interfere with the interim order under swan. So, in view of the decision of the Honorable Supreme Court, that's the alternative remedy there. So, this is the yes.
Obligation.
Aja, he is appearing for the bank. You are appearing for the bank, na? Yes, next.
Item 19.
I have challenged of the revenue record prepared, ignoring the lease in my favor. Now the person may look at annexure 1, plot index, then annexure 2. This is a lease out to me. My husband, Jogendra Bhatt. Page 13.
No, which order you are challenging here?
I challenging the record of right.
The record of right.
Yes.
So directly after High Court.
Record of right.
There the Yabjas was prepared. Annexure 4. There was a recording that
Note of position.
His whole property. Behind back the matter proceeded and ultimately record of right has been published.
So
under the
writ will be issued.
Act. So I could have filed revision under section 15B. But my husband died in the year 2014 when the record of right was prepared. Before that, he died just before that. So I could not take any step. Several cases were filed before this court in irregularities so far as that periphery is concerned, Bhubaneswar and Cuttack. And this honorable court, by its judgment.
No, we are on limited question that how, when the alternative remedy is available to you against the impugned order passed under Annexure 1, and particularly when there is inordinate delay, why we will entertain that petition, this writ petition.
Because your lordship may look at the leaseable property. If the lease is not cancelled,
can you not take that ground before the alternative remedy in the order?
No. Because my husband died.
If there is any question of limitation, you can also take that ground, file your death certificate of the husband.
I will approach the revisional authority. Under the Settlement Act, liberally be considered.
The Learned Counsel for the petitioner, for example, petitioners have filed this writ petition challenging you are challenging what?
Annexure 5, the record of right. So far it relates to plot number 390.
That the final ROR of Khata number 4684, right?
684.
The Learned Counsel for the petition, which was published on 30/12/2013. Yeah, it appears from the.
Yes. In 14, my husband died.
The Learned Counsel for the petitioner submits that the petitioner has got alternative remedy as against Annexure 5. He can approach the provision of
15B of the Orissa Service Settlement Act.
15
of OSS Act.
15B, Lordship.
Yes. in small b.
Small b. On application made within 1 year from the date of final publication of under section 12b, the revision of the record of
Which 15b, which states inter alia that the Board of
revenue
in any case direct on application made in 1 year from the date of final publication under section 112b, the revision of record of rights or any portion thereof, whether within the said period of 1 year or thereafter, but not so as to affect any order passed by a civil court under section 42. The Land Council for the petitioner submits that the time stipulated in the 15b of 1958 Act for the Odisha SARFAESI loans, after bracket like 1958 is already over, and since the petitioner's husband expired in the year 2014, he could not take steps earlier before the revisional authority, and he may be permitted to withdraw this expedition to approach the revisional authority within 4 weeks for the one, 3 weeks, within 3 weeks, and if you make the application for condonation of delay is filed, the same may be directed to be considered sympathetically. The Land Council for the state has no serious objection to such prayer. In view of the submission made by the Land Council for this one, so since alternative remedy is available to the petitioner to challenge annexure 5, this petition is disposed of with observation that in case the petitioner approaches the revisional authority and files an application for condonation of delay in entertaining the revision petition, same shall be considered in accordance with law, taking into account the submission that was made and that the husband of the petitioner expired in 2014, provided that the death certificate is filed in support of such contention, and the matter may be heard on merit in accordance with law. Yes. And Mr. Siddharth Mr. Parguve, Land Council for the petition. Mr. Nayak, Land Council, Additional Government. Yes.
Item 20.
State Bank of India for your lordship, challenging the inaction of the opposite party number 1 land acquisition officer in not disbursing the compensation amount in favor of the State Bank, which is a mortgagee of the lands, my lord. My lord, may kindly see, if your lordship will see at page 19, sorry, at page 15, what had happened, my lord. One Sapna Builders had taken a cash credit loan.
No, the land is recorded in the name of, let us say, X. He kept that mortgage under in you and take a loan. So
their OA is pending, my lord. We had claimed a certain amount, and at page 53, land acquisition proceedings were initiated. Then from the office of the land acquisition collector, we got a letter. Before that, we had written 2 letters. If your lordship, only 2-3 pages, page 61 onwards, my lord, also 3-4 pages. In 2022, my lord, we wrote to the opposite party number 1 that the bank is the mortgage of. ଆମର ଅଛି OA ଅଛି, ଆମେ possession ବି ନେଇଯାଇଛୁ. That order have also included OA ବି ମୁଁ ଦେଇଛି. So one of the properties of one of the mortgages to that proprietor is subject matter mortgage. Whatever amount you give to that some amount, this is the amount, please apportion in our favor. We gave at 61 at page 62. At 63, my lord, may kindly see annexure 6. We got a letter from them. 63, my lord, may see.
Land acquisition of
yeah.
Hon'Ble.
Kindly see, my lord. To the Chief General Manager, SBI so-and-so branch, providing information on outstanding dues, inclusive of interest. This is to inform you that the following account holder is one of the land loser due to acquisition of land for construction of NLCIL Talabira Thermal Power Plant
entity PP Jharsuguda, and as such he is entitled to compensation from this office. However, it is learned that he is one of the loanee from your branch, and on default payment in this part, the SARB Sambalpur has approached the Jharsuguda District Administration under Section 14 of the SARFAESI Act. In this regard, I am to request you to intimate us the present outstanding inclusive of interest as on 16/7/2024. So that this office can put hold up to that amount and release the balance to the person.
ଅସୁବିଧା କଣ ହେଲା?
ଅସୁବିଧା ଆଜ୍ଞା ହେଲା, pursuant to this letter, we send letters on 18/7/24, that is the next annexure, at 64 and 65.
ଦେଲେ ଏତିକି ଟଙ୍କା ଆପଣଙ୍କର ପାଇବାର entitlement.
ହଁ କି ଆମର ଆଜ୍ଞା update ଆମର ଆଜ୍ଞା ଏହା ପାଇବାର ଅଛି।
କଣ?
So what happened, my lord? Kindly see 67. That is the land acquisition register, my lord. ସେଥିରେ ସେମାନେ କଣ କଲେ? Kindly see 67, my lord. ସେଥିରେ total dues ହେଲା, total ହେଲା compensation 2,06,81,238. ସେଥିରୁ 1,13,83,000 ସେମାନେ kindly see right hand side ସେମାନେ ଦି ଜଣଙ୍କୁ ଦେଇଦେଲେ। 92 lakhs जोटा आमे claim करथुलु, then your lordship see left towards the bottom जो तीनटा line अछि is withheld. So now this amount they are not disbursing. If your lordship will see section 7,
order ମାନେ କେବେ ତାଙ୍କୁ
ଏଠି ତ ଆଜ୍ଞା 2024 ର, if your lordship will see their letter,
3/8/2024
ଆଜ୍ଞା
The land is recorded in the name of the private opposite party. That land is mortgaged before the bank, and that land acquired by the government, my lord. Now the collector has no authority to release that. Only under section 30 of the Land Acquisition Act, the collector will refer the matter to the.
no my lord, may kindly see section 77 for a moment. 23 रे आगे award हुए, 30 रे solatium add है कि हुए. Kindly see 77. 77 रे, if there is no objection, kindly see my lord 77.
77.
The 39. That is my case.
But you say that OA is pending?
OA रे तो हमारा claim अच्छी आ गया.
So it is yet to be finalized that you are paying the first charge.
The LAO has accepted our claim. He has told.
No, LAO has taken it, and that is how the amount has been withheld. So it will be given to you, no doubt about it, the moment the order passed by OA.
That is why I was pointing out that land acquisition register.
Pending before the
DRT रे pending अछि.
DRT holds against you. How do you take the money in advance?
My lord, because I was showing that land acquisition register, when this amount was withheld, the other amount has been taken by the others without this.
It must have been filed by that borrower.
Bank na
bank.
I filed that way also.
कौन टाइम फाइल कले आपण?
सी एक्चुअली गोटा सपना बिल्डर बोली गोटा प्रोप्राइटरशिप फॉर्म थिला गया, गोटा 60 लाख से गोटा सीसी लोन नहीं थिले। सेतिरे माने not only this property which is a land acquisition, other properties were there. So that is pending. ए माने भी पक्ष अछथि जीवन को रिट रे भी पक्ष करिछि।
आपण एटा को
13 Act
2013 Act.
आगे My lord, may kindly see. Payment of compensation or deposit of same in authority. On making an award under section 30, the collector shall tender payment of the compensation awarded by him to the persons interested, entitled thereto. Yes, I will show that definition also. Entitled thereto according to the award, and shall pay it to them by depositing the amount in their bank accounts, unless prevented by some or one or more of the contingencies mentioned in subsection 2. So ordinarily, my lord, if some of the persons were interested, and by that letter he has accepted that we are one of the persons interested. That letter has been issued, I was showing to your lordship, of 2024. It is from the Office of the Land Acquisition Collector.
No, what is the definition of person interested?
Yes, it is there, my lord. Section 3 re achi again. Section 3 re, my lord, may see section 3, clause 10. Person interested. All persons claiming an interest in compensation to be made on account of the acquisition of land under this act. This is the only one on which I am relying upon, my lord. So, my lord, that is broad enough to encapsulate the right of the bank as a mortgagee. And in the register which I have filed, my lord, they have taken the amount which was due to them, excluding the share of the bank. So, under 77, they have not objected.
No,
this is the first time it has come. I have made all of them parties also, my lord.
Because they might have
yes,
any other proceeding.
My lord, yes, my lord, admittedly, to the date of my knowledge, there is no objection. Yes, yes, I pray also, my lord.
This petition has been filed by the
State Bank of India,
petitioner, State Bank of India's
through its
petitioner,
authorized officer.
authorized official, with a prayer for a direction
To the opposite party number
to
one.
the opposite party number
One, my lord.
one.
To disburse
To
the, my lord.
disburse the amount of rupees 92 lakh and 90,156 in favor of the petition out of the total awarded amount
2 crores देखोतले आगे
of rupees 2 crores funds. So pay
2 crores 6,81,238.
77 as the right to fair compensation and transfer 2013 after passing of the award under section 30 of 2030 in allocation number so and so. The land council for the petitioner submitted that the opposite parties number 3 to 5 have held loan. Dekhichen egoda ke
2 to 5. I have included the OA and the 13 to order of district magistrate,
2
everything.
to 5 na
2 to 5 आ गया. 2
Acha,
2
2 to
2
5.
2 had taken the loan, MNL, mortgager and guarantor. 2 had taken the loan,
2 had availed the loan from the bank, petitioner bank. Kevin is
again, they had taken some time in my lord.
In the year 2000.
I have written that detail.
2011, paragraph 3.
My lord. 2011 and again in 2017 it was enhanced.
2017.
Arrangement was made.
The arrangement was made in 2000.
60 lakhs CC नहीं थे लगे.
And ultimately, when the loan amount could not be repaid, the bank took steps under the SARFAESI Act and the
also filed OA also, my lord. 255 of 20.
Food election.
लेके जाएंगे 255 of 2020.
70.
It is, I have included that OA copy also.
255 of 2020.
Which is pending.
Before the Land DRT.
Again.
And DRT Cuttack, which is sub judice.
Again.
It is further argued that the land in question was acquired by the government under Land Acquisition Act, and the petitioner was issued a letter by the Land Acquisition Officer Suda on 16/7/2024, wherein it is indicated that
63, my lord, it is page number.
All right. That since the account holder bracket is opposite party number 2 is one of the land loser due to acquisition of land for construction of NLCIL Talabira thermal power plant bracket into NTTPP Jharsuguda, and as such he is entitled to compensation and that the bank has already approached the Jharsuguda district administration under section 14 of the SARFAESI Act. The bank was requested to intimate the outstanding dues inclusive of interest so that the amount can be put on hold and released the balance in favor of the person concerned. It is the contention of the Land Council for the petitioner that in pursuance of such letter, the bank furnished number 2, and it indicated that the outstanding dues against the opposite party number 2 was 92,98,156. However, the
for 65 we wrote a letter to them कि please release that amount under section 67.
And
Page 65
was issued
Under
by the
Annexure
bank
8.
on the by Annexure 8
ଆଜ୍ଞା
to
to disburse ଆଜ୍ଞା last paragraph में लिखा
Disbursement.
76
the
77
amount
लिख ଦେଇଛନ୍ତି
of
actually
rupees
77
that's one so under section 76
ସେ ଆଜ୍ଞା ଭୁଲରେ 76 ଲେଖିଛନ୍ତି 77 ବି ତାପରେ ଲେଖିଛନ୍ତି
under
actually
77
77
of this one so the ତାପରେ order ଟା କଣ କଲା the land acquisition officer ଝାରସୁଗୁଡା did not take any action rather disburse amount of rupees 1 crore 13 lakhs one so annexure 7 9 in favor of the other persons so far as the amount to which the petitioner opposite party number 2 is entitled to that was not disbursed in favor of the opposite party number 2 and the that has been withheld
ନାଇଁ ମ୍ୟାଡ଼ାମ in favor of the petitioner ଟା ଯୋଉଟା ଥିଲା that has been with ତାଙ୍କୁ ସେମାନେ ଦେଇଦେଲେ ତାଙ୍କ ପଇସା
that he was supposed to give to the opposite party number 2 because his land was acquired na
ଆଜ୍ଞା ତାଙ୍କୁ ଦେଇଦେଲେ 2 to 5 କୁ ଦେଇଦେଲେ they have signed ଆଜ୍ଞା they have received
When after apportionment has been made, 2 to 5 shares have been disbursed. Your share being the mortgager, mortgagee, you have not been disbursed.
Aye.
Though it is apportioned.
that is under challenge before you
share has been withheld stop issue notice on the question of admission indicating therein that matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of the opposite party number 1. Repudiates provisions of notice on opposite parties number 2 to 5 shall be filed by next week. Put up this matter in the week commencing from 16th December 2024. Counter affidavit, if any, be filed in the meantime. Land Council for the state shall also obtain instruction. Yes.
much obliged
बाकी उड़ा तो काटी ना
Pardon to mention, item 3, my lord. I pray 1 week after, my lord.
Wait. And the matter reaches please.
Supplemental list for orders item number 1.
My lord, I may be pardoned for mentioning. My lord, item number 20, I will not do this. So
Wait, ask somebody to make a mention. We are going serially. Yes. Item number 1.
Right, lordship, my lord. In this case, my lord, the appellant is custody 13 years 4 months, my lord.
The prayer from the by the prisoner,
my lord,
and you have filed your vinama.
My lord.
Is the sole appellant?
Yes, my lord. Sole appellant.
Let us hear the prisoner's petition at flag D, wherein there has been made for engagement of advocate Chittaranjan Sahu, counsel as his counsel. Prayer is accepted. Mr. Sahu has already filed vinama. Vinama achi to? Verify kona? Vinama. In view of the filing of the vinama, the names of other counsels shall not be reflected in the project. Yes, make your submission.
Yes, in this case, my lord, that that the petitioner is the nephew and he is suspecting to the deceased.
It's a 302 case.
Yes, my lord. Suspecting to witchcraft, my lord, out of a
Have you been ever released on bail by this court earlier?
No, my lord.
Rejected.
2012. So it was rejected in the
2020.
In the year, my lord.
13/1/20. Okay, so how many years you are in custody?
His custody, my lord, 7/7/2011, my lord.
7/7/2011.
Yes, my lord.
That means you are not on bail during trial.
Yes, my lord.
7/7/11 ठीक है 8/7
8/7.
Okay, और चीज लिख रहा हूँ Produced in custody. Produced in custody. ତ ଆପଣଙ୍କର ଏଇଟା 13 ବର୍ଷ ହେଇଗଲା।
Very much, madam.
କଣ allegation କଣ?
Allegation of suspecting the witchcraft committed murder by means inflicting sword blows, my lord.
How many deceased are there in this case?
One, my lord.
One.
One deceased. PW16 is the eyewitness. PW16 is the eyewitness.
Eyewitness. Explain that again.
Oh, beheaded. He was beheaded.
Was along with him while he was returning in the bay, my lord. He has committed murder, my lord.
So there are two witnesses, PW11 and PW. 11 is also the son.
11, my lord. Son of the deceased, my lord.
11 is the son of the
deceased.
Are the land and council petition and council for the state? The land council for the petition submit that the petition is in judicial custody since 8/7/2011. His bail application was earlier rejected by this court on 13/1/2010. And since he has remained in custody for more than 13 years. And there is no chance of appealing the bail application may be favorably considered. Land counsel for the state opposite prayer for bail and place the evidence of 11 and 16. With the doctor.
PW1 minute.
PW1 minute.
So also the evidence of the doctor PW1 is conducted post-mortem examination. Considering the submission made by land counsel for the respective party, the culture of evidence available. Was not in planning to release the petitioner on bail on merit for taking into account his period of detention, judicial custody, and keeping in view the ratio laid down in litigation 3 months bail granted, stay violation of fine. Yes. Huh? File करना अपन केवल file नहीं ଆପଣଙ୍କର ଯେହେତୁ ଆପଣଙ୍କର ସିଏ ପ୍ରିଜନର ପିଟିସନ ଦେଇଛି ଆପଣଙ୍କ ନାଁଟା ଚାଲି ଆସିଛି ତ ଆପଣ ଭି ନାମ ଫାଇଲ କରିଛନ୍ତି ନା ମୁଁ ପଚାରିଲି ସେଇଥିପାଇଁ ଭି ନାମଟା ଫାଇଲ କରିଛନ୍ତି ସେଟା କାଟିକି land counsel for the Mr. Sahoo submits that he will file a nama within a period of 2 weeks. Yes.
Item 2.
इस सप्ताह भीतर फाइल करूँ तो भी ना है ना
There are two appellants, and the appellant number 2 was granted bail, and in the meantime, my lord, he has been expired, my lord. Therefore, I have filed an application to abate the appeal against the appellant number 2, my lord.
Appellant number
2 has expired.
He expired color?
2.
So where is the certificate, death certificate?
Yes, my lord, I have annexed in my IA. The lordship
Linga
can
Naik.
see that is IA number.
Have you ascertained your taking your instruction?
Yes, sir, I received the death certificate. Copy.
No.
No, we have to take instruction.
Correct that she has filed death certificate, but as per law, you are to obtain instruction. IA number.
My lord, another application.
Just project. IA number so on. So it is an application. filed under section 394 of CRPC for abatement of the appeal in respect of appellant number 2, Linga Naik. The Learned Counsel for the petitioner submits that he said Linga Naik was directed to be released on bail by this court by the order dated 18/4/2016. However, while on bail, he has expired on 5/12/2020. The death certificate issued by the Register of Birth and Death, Chudapalli, has been annexed to the interim application. Copy of the interim application has been served on the Land Council for the state who seeks some time to verify, to obtain instruction on this end. Hello? So, put of the matter. Utanaida. Yormali. Malangi Soto. This matter will be commencing on 2nd of December 2020.
But I have filed an application for bail of the appellant number 1, my lord. My lord, he is inside custody since, my lord,
number 1 la Madan Naik.
Madan Naik, 20/5/2011, and committing murder of 2 persons, my lord.
5/5/2011.
My lord, committing murder of 2 persons.
So,
There are eyewitness to the occurrence. They are PW 85.
Get the custody certificate, because sometimes what has happened during that COVID period, they were released on parole. So take instruction whether the submission that since 2011 he has never been released on bail, or he has been released on parole during that particular period. Which jail is there? This man is there.
Yeah.
Which jail ଅଛି?
କୋଉ ଜେଲ ଅଛି? ମଦନ ନାୟକ। ଏ ବଲାଙ୍ଗୀରରେ କୋଉ ଗୋଟେ ଜେଲ ଅଛି?
ଏଇ ନାମଟା କୋଉ ଜେଲରୁ ଆସିଥିଲା? ହଁ, ବଲାଙ୍ଗୀର ଜେଲ, ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ବଲାଙ୍ଗୀର। ଲେଖନ୍ତୁ IA number 151 of 2021. This is an application for bail of appellant number 1, Madan Naik. With the Bani Mahapatil and counsel for the petitioner submits that the appellant number 1 is in judicial custody since 25/2011, and he was never released on bail during trial. And
Not also in the appeal, my lord. His bail application has never been rejected.
Also, he has never been released on bail. However, the Land Council for the state takes some time obtain instruction to produce the custody certificate for this matter. Same date or
Date.
Jail Balangir jail wakalat namaz.
Date.
Date
2 December.
2/12/2024.
आगे।
Item 3.
I pray for my lord 15 days time, my lord. I pray for 15 days time, my lord, to collect the documents, my lord.
The Learned Counsel wants to for bail, Learned Counsel for the appellant. It's who's adjournment. Put up this matter urgent. Yes, next.
Item 4.
May I please?
Item number 5.
Yes.
I filed 2 IA, my lord. 1 IA for bail.
Prisoner's petition আসছে
My lord, I filed my वकालत मध्ये.
Every matter deposition copy line. Deposition copy.
तो अच्छा बना प्रैक्टिस करें ना.
how many appellants are there?
Only one appellant.
Period the prisoner's petition at Flag X, in which PR has been made to engage Mr. Vishwajit Naik, advocate, as his counsel. Where is accepted. Mr. Naik has filed Dinama. This is taken on the report. Yes, what do you say?
There is no deposition copy.
You are having the deposition copy. Either you supply or take the from the pen drive. Yeah. Yeah,
Mail.
pen drive नहीं जान तो सुविधा हो.
Mail.
ମୁଁ ବି ଗୋଟେ ଦେଇ ଦଉଛି.
The Lion counsel for the state submit that he is not having the copy of the deposition. Let the Lion counsel for the appellate supply a set of deposition
ରାଜି ଦେବି.
by tomorrow. Matter will be placed commencing from 25th ଆସିବ.
Item number 6.
Appeal bail, my lord. The custody since my lord 4/1/15, my lord. And so offense under section 302, my lord.
Prisoner's petition कौन आशी कहाँ पे engage किया?
My lord, my name, my lord. Deepak Ranjan Mishra, my name.
Right. So you also filed Dinama.
My lord.
Right. Fill you the prisoner's petition at Flag X, in which there has been made to engage Mr. Deepak Ranjan Mishra, advocate, as his counsel. Prayer is accepted. Mr. Mishra has already filed his Dinama. He is taken on record. Yes, what is your submission?
My lord, deposition copy not available.
Taking from the pen drive नहीं जाता.
Mail ले सुविधा.
हाँ?
Mail की WhatsApp पे.
Mail.
My lord.
You are not having the pen drive with you.
Pen drive.
Mail कौन आवा? High Court RG अपन को mail करियो ना कौन?
My lord.
It is available. Just get a pen drive. आजिकली समय गला नि pocket रे पुरे किन बुलोन. हला? Paperless court हो जी तनो. The Land Council for the state, so also the Land Council for the appellant submit that they are not having the deposition copies. Let the registry supply the same pen drive to be supplied by the Land Council for the respective party. Matter will be placed to be commencing from 25/11/2020. Yes.
Item 7.
Is a petition from the appellant and is engaged another from all its.
G. Bihari Mishra and his associates.
My lord.
Business person is at Flag C. Flag C, कहाँ पे engage करें जो
I'm filing booklet now, my lord. Business person.
Wait.
ପୂର୍ବତନ ଓକିଲ ପୂର୍ବତନ
Please wait. ମୋର ପୂର୍ବତନ ଓକିଲ ଅନନ୍ତ କୁମାର ଆଚାର୍ଯ୍ୟଙ୍କୁ ବଦଳାଇ ନୂତନ ଓକିଲ ରାଜୀବ ମିଶ୍ରଙ୍କୁ ମୋର କେସ୍ ପରିଚାଳନା କରିବା ପାଇଁ ଅନୁମତି ଦିଆଗଲେ ମୁଁ କିଏ
I'm filing power, my lord.
ଆଚ୍ଛା ଦିଅନ୍ତୁ. The prisoner's petition. Flag C, in which request has been made to engage Mr. Rajiv Mishra as his advocate. Mr. Mishra has filed Dinama. name of other counsel shall not be reflected in the first instance court.
My lord,
Yes, what do you say?
I lord on 956 over 2019 for bail, my lord. 956.
Asini to hai na?
The bail application number is something different. It's
956.
729 of.
Who are you? Who are you? You are he is the counsel for the petitioner appellant. He is to submit. Who are you? You are the informant. Are you for the informant or what?
And he was earlier engaged.
Earlier engaged matter ends there. He has written. So he kete number apon karo?
My lord of 2022, my lord.
956.
729.
729. That is there in the list.
My lord.
So you want to move it?
My lord.
So what is the period?
The period I am in custody, my lord. 14/10/2014 custody certificate is with me. Custody certificate is with me.
14/10?
14/10/14, my lord.
14/10/2014. Forward along for.
I have custody certificate, my lord.
Custody certificate aschi.
I'm fine, my lord.
Kete hochi? 10 ବର୍ଷ 9 ମାସ 24 ଦିନ ଏଟା କେବେ କାର ଡେଟ୍ କେବେ?
30/10/24.
30/10.
କଣ allegation କଣ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି କି?
ନାଇଁ no my lord. Never rejected.
Okay. କଣ ହେଲା prosecution case?
Prosecution case is my lord. One is the who is the informant, my lord. His law is FR is different, my lord.
Offense is 302.
My lord.
Oh.
Remains no attention.
No, what is the prosecution case?
Prosecution case, my lord. There is a relation direct demand was there.
What is the name of the deceased?
This is
Swarnalata Barar.
My lord.
Elias Kunni.
Barar. Alias
Kunni.
How you are related to the deceased?
No related. There is allegation some affair with me.
Are in-laws nୁହେଁ ତ କଣ?
No.
ଆପଣ କେମିତି ପଢିଲେ କଣ evidence କଣ ଅଛି?
Evidence ଅଛି PW5 and PW7 କହୁଛନ୍ତି ସେ ଶୁଣିଲେ ପୋଖରୀ ପାଖରେ. No eyewitness circumstantial evidence, my lord.
No eyewitness. Evidence of PW5 and PW7.
ଆଜ୍ଞା.
ଆଚ୍ଛା. ସେମାନେ କହୁଛନ୍ତି ଆମେ ଶୁଣିଲୁ.
ସେମାନେ କହୁଛନ୍ତି ଆମେ ଯୋଉ ସ୍ପଟରେ ପହଞ୍ଚିଲା ବେଳକୁ ଟ୍ରକ୍ସରେ
We heard shouting of Swarnalata. ବୁଢା ମୋତେ ମାରି ପକାଉଛି ମୋତେ ବଞ୍ଚା. ବୁଢା କିଏ?
ବୁଢା nickname of
appellant.
From near the pond which is situated near our house, locally so-and-so. Hearing such shouting of Swarnalata, my husband, my brother, so-and-so, proceeded to see a Pokri and we followed him. My brother-in-law, my nephew brought my daughter-in-law from the pond. We bought her near our residence, found one cautery inside her sari. We further noticed several bleeding injuries in the Swarnalata was not talking, but we expected she was alive. We gave her hot milk, but she could not respond. Thereafter, we suspect Swarnalata is dead. Father of the accused came to the assurance he had seen the cautery and the narrator found and so on. So. Before the death of Swarnalata, the accused was in love with so and so. Accused and the Swarnalata were giving letters to each other. They were also talking over phone. Accused committed murder of Swarnalata as his love with her could not be materialized. The 5 number and 7 number भी सही evidence.
Okay.
7 number तो किछ कहनी. खाली
जौन है.
7टा तो ये
witness.
So 5 is the old witness who some or other stated about the dying declaration.
No dying declaration.
No, probably PW6 is there.
6 is there.
No.
Susila Mote ସୁଶୀଳ ମୋତେ ହାଣନା ମୋତେ ବଞ୍ଚା.
I also shouted, many people came there, including family members of Sonalata.
chairman of PW5 କହୁଛି ସ୍ୱର୍ଣ୍ଣ ବୁଢା ମତେ ମାରି ପକେଇଲା ମତେ ବଚାଅ ଏଠି ସେ ସିମିଲାର ଏକ୍ସାକ୍ଟ ଇଏ କଥାଟାକୁ ସେ କହୁଛି ଓଲଟା କଥା ସେ
ସୁଶୀଳ ମୋତେ ହାଣନା ହାଣେନା.
ବଚାଅ
ସୁଶୀଳ କିଏ?
ସୁଶୀଳ
is the
Appellant.
the appellant petitioner.
ଏଇଟା ନିକ୍ ନେମ୍ କି ଗୋଟେ
ବୁଢା
ସୁଶୀଳ
alias
ଗୋଟେ-
ସୁଶୀଳ.
ହଁ
ବୁଢା alias ସୁଶୀଳ.
ବୁଢା ଏଇ ଯୋଉ ଏଥିରେ ଯୋଉ କଜ୍ ଲିଷ୍ଟରେ କଣ ଲେଖା ହେଇଛି ତୁମ୍ବା ମୁଣ୍ଡା ଏଇ ମ୍ୟାଟରଟା ତ ଆପଣଙ୍କର?
No,
No, no, seven.
ବୁଢା alias ସୁଶୀଲ କୁମାର
ଆଚ୍ଛା ଏଇଠି ହଁ ବୁଢା alias ସୁଶୀଳ. What is the report of the doctor? ତାମାନେ PW5 ଆଉ 6 ହେଲା ଡାଇଂ ଡିକ୍ଲାରେସନ ବିଷୟରେ ଆଉ ଡକ୍ଟର ଇଜ
PW8.
right my lord PW5 and PW ଇଏ କହୁଛନ୍ତି we heard the shouting of ଇଏ
ହଁ
shouting ଟା ଶୁଣିଲେ ଚିଠି ଯେ ପହଞ୍ଚିଲା ବେଳକୁ ସେ କହୁନି ତାଙ୍କ ଆଗରେ କହିନି it is not dying declaration my lord.
PW5
Yes, my lord.
we heard the shouting of Swarnalata so and so from near the pond which is situated so and so. Shaw number I heard Swarnalata was shouting
Otherwise,
କଣ ଆପଣ ସବମିଶନ କଣ?
Kindly take a glance at PW2 informant father of the
ନାଇଁ ଏଇ ଯୋଉ ଆପଣ ସବମିଶନ କଲେ କଣ ଡାଇଂ ଡିକ୍ଲାରେସନ କଣ କହିଲେ କଣ?
dying declaration ନାହିଁ my lord. Only hearing the sound of deceased there
ଡାଇଂ ଡିକ୍ଲାରେସନ କଣ କେମିତି ହୁଏ?
no dying declaration we is not saying before
ଜଣେ କହିଲା ଯେ ମତେ ଇଏ ମାରି ଦଉଛନ୍ତି so how why it would not be taken as dying declaration? ମତେ ଏ ଲୋକଟା ମାରୁଛନ୍ତି
respectful submission
ସେ ପାଟି କରି କହୁଛି
ପଏଣ୍ଟ ରେ ଅଛି ପଏଣ୍ଟ ପାଖରେ ଆଣୁଛି ଇଏ ତାକୁ ଆସଲ୍ଟ କଲା ସାଉଟ କରି ଏମାନେ ଶୁଣିକିରି ଗଲେ ସେ ସେତେବେଳକୁ ସେ କହିବା କଥା ସାଉଟିଂ ଟା ଦିଟା କଥା କହୁଛନ୍ତି ଜଣେ କହୁଛନ୍ତି ମତେ ମତେ ମାରିଦେଲା ଇଏ କହୁଛି ସୁଶୀଲ ମତେ ମାରିଦେଲା ଜଣେ ଲୋକ ଆଜ୍ଞା ଦିଟା କଥା କହିପାରିବନି ମେ ବି ନିକ୍ ନେମ୍ ଡିଫରେଣ୍ଟ ନେମ୍ ଡିପୋଜ ଦେ ଆର୍ ଡିପୋଜିଂ ୱାନ୍ ଇଜ ସେଇଂ ସ୍ୱର୍ଣ୍ଣ ବୁଢା ମତେ ମାରିଦେଲା ଏପଟେ ଇଏ କହୁଛି ଆଉ ଗୋଟେ ନାଁ କହୁଛି ସୁଶୀଲ ମତେ ମାରିଦେଲା
ଯାହା କହିଥିବ ଗୋଟେ ଥର କହିଥିବ ଆଉ ଦ୍ୱିତୀୟ ଥର କହିନଥିବ
ଦିଟା ନାଁ କେବେ କହିପାରିବ
ନାଇଁ ନାଇଁ
This is my
ତୃତୀୟ
responsibility,
ଥର କହିନଥିବ ଆଉ ଏଇଟାକୁ ଆମେ ବେଲ୍ ଷ୍ଟେଜରେ ତାକୁ ବର୍ତ୍ତମାନ ଆପ୍ରିସିଏସନ କରି ଆପଣ ଛାଡିଦେବୁ ନା କଣ? ଖଲାସ କରିଦେବୁ ନା?
kindly take a glance PW2 minor. So inform father of deceased man. Father of deceased man. PW2. Tirlochana Bora. I am the informant of this case. I know the accused present in the dock who is residing of village Korila. My eldest daughter Sonalata Rao alias Puni alias Borsa was giving marriage to Saroj Kumar Rao of Tonga Korila about 9 years back. My daughter after marriage was staying in the house of her in-laws. My son-in-law Saroj was working as a plumber and staying at Nepal. He used to come to village on intervals. My daughter was blessed with 2 sons. My daughter Sonalata died on 11/14 and by the time she was staying in the house of her in-laws. The father-in-law, the mother-in-law of my daughter, namely Labakishore Rao and Usharani Rao, the brother of Labakishore Rao, namely Dapura Narayana Rao, demand cash of 1 lakh from me as dowry. I could not comply such demand. Therefore, my daughter was subjected to harassment by them. On 11/14, I got a telephone call from Dapura Narayana Rao that the condition of my daughter, Pidul was serious and she intimated me to come immediately. On getting such intimation, I came to the house of in-laws of my daughter and found my daughter lying dead. I found several marks of injury on the persons of my daughter. In the same day, I lodged a written report about the death of my daughter at the police station.
That FIR was not against you.
No.
That was against the in-laws family.
Yes, my lord.
So during course of investigation, these two witnesses came up and said that
They are the in-laws, madam. They are the interested in one family, madam. Same family of the deceased.
पांच और छह
My lord.
शिक्षक जी को विलेजर
पांच number होची से पूरा कोची I know the informant whose daughter, namely Swarnalata, has marriage to my son. Soshvachara. Oh.
They are the interested witness.
5 or 6. I know the informant whose daughter Swanti was married to Sarojana Sonowans.
सुशील 40 बुढ़ा
Case ये जो illicit relationship ऊपर किसी ଆଉ କିଛି evidence ଅଛି ଆଉ ଚିଠି ପିଠି କଣ ଲେଖୁଥିଲେ ବୋଲି କଣ ଆସୁଛି କଣ
ଚିଠି ଡିଫେନ୍ସ ରେ my father ଡିଫେନ୍ସ ସପୁରିଟା ମିଳିଛି ଡକ୍ଟର କହିବା କଥା କଟୁରେ ଯୋଉଟା କଟିଂ ମାର୍କ ଅଛି ସେଟା ବୋଥ ସାଇଡ୍ ସାର୍ପ ୱେପନ ହବା ଦରକାର କିନ୍ତୁ କଟୁରେ ୱାନ୍ ସାଇଡ୍ କଟୁରୀ ସ୍ପଟରୁ ମିଳିନି
ଡେଡ୍ ବଡି କୋଉଠି ମିଳିଲା
ଡେଡ୍ ବଡି ସେମାନେ ଟେକିକିରି ଆଣିକି ତାଙ୍କ ଘରେ ଚେଞ୍ଜ ଚାଞ୍ଜ କରେଇଛନ୍ତି ଡେଡ୍ ବଡି ପଣ୍ଡ ପାଖରେ ଇଏ ଡାକିଲା ମାନେ ଦୌଡ଼ିକିରି ଗଲେ ଦୌଡ଼ି ଗଲା ପରେ ଦେଖିଲେ ଯେ ଦିସ୍ ଇଜ ସରି ଆକ୍ୟୁଜ ରନ୍ ଆୱେ ଦ କ୍ରସ୍ ଲାଇଟ୍ 6 and 7 5 and 6 ର ଡିପୋଜିସନ ମାଇଲା ସେମାନେ ଆଣିକି ଆସିଲେ ତାଙ୍କ ଘରକୁ ଘରେ ଚେଞ୍ଜ ଚାଞ୍ଜ କଲେ ଦେଖିଲେ କଟୁଟା ତା ଭିତରୁ ବାହାରିଲା କଟୁରୀଟାକୁ ସେମାନେ ପରେ ଆଇଡେଣ୍ଟିଫାଇ କଲେ ଯେ ଏଇଟା ହଉଛି ଭିଲେଜର କହିଲେ ଯେ ଏଇଟା ତାର ହେଇଛି ବୋଲି ଡିଫେନ୍ସ ୱିଟନେସ୍ ଫାଦର ଡିଫେନ୍ସ ୱିଟନେସ୍ ଡିପୋଜିସନ DW1
ନାଇଁ ସେ ପଢଉଥିଲା ବୋଲି କିଏ କହିଲା
ଏ 6 5 ଆଉ 6 5 and 6
ଆସିଲା ସେ ଏଭିଡେନ୍ସ କୋଉଠି ଥିବ informant examine ହେଇଛି PW Okay, come to the doctor's evidence. PW.
PW8 page 124 मिला
para 7 madam
Just a minute. This weapon was produced before the doctor.
produced doctor without seal and
No. What is the opinion given? The doctor evidence does not show that any opinion he examined the ପୁରା ତ କଟାରୀରେ ଇଞ୍ଜୁରି ସବୁ ହବନି ବୋଧେ ଏଟା ଷ୍ଟାବ୍ ଉଣ୍ଡ ମାନେ ଏଗୁଡା ସବୁ
ଷ୍ଟାବ୍ ଉଣ୍ଡ ଅଛି ନାଇଫ୍ ଥିବ
ନାଇଫ୍ ସବୁ ଗୁଡାକ ନାଇଫ୍ ରେ ହେଲା ଭଳିଆ ଲାଗୁଛି ନାଇଫ୍ ବା ପଏଣ୍ଟେଡ୍ ୱେପନ୍ ରେ ଏଗୁଡାକ ସବୁ ହେଇଛି ଷ୍ଟାବ୍ ଉଣ୍ଡ ଗୁଡାକ ଭିତରକୁ ପଶିଛି ଡିପ୍ ପଶିଛି ସବୁ ଗୁଡାକ ପ୍ରାୟ ଡେପ୍ଥ କୁ ଅଛି ତାର ଇଏ why it was not produced before the doctor to obtain his opinion, Mr. Naik? ये जो ordinarily से जो कटरी रे इंजुरी हेले incised wound हबो cut wound हबो stab wound गुड़ाक सब pointed weapon रे knife गुड़ाक सब वे बुक्ति सब रे आपनकर stab wound आसो गुड़ा की आदि रहीच ତେଣୁ ये weapon ଟା ଆପଣ seize କଲେ produce କଲେନି କାହିଁକି stab wound is possible only by a sharp cutting weapon having both side ଦି ପଟେ ଯଦି ଥିବ ତାକୁ ସେଟା କଟୁରୀ କେମିତି କଟୁରୀର ତ
both side ଟା ନଥିବ
କଟୁରୀର ଗୋଟେ ସାଇଡ ବ୍ଲଣ୍ଟ ଅନ୍ୟ ସାଇଡ ଟା ଇଏ ଥାଏ
ସାର୍ପ ଗୋଟେ
ହଁ ସାର୍ପ ଗୋଟେ ରଫ୍ ଗୋଟେ
P6 that's why I stated that they brought her to their house. A cottery was found under the clothes of Swarnalata was changed.
ଶାଢୀ ଭିତରେ ଥିଲା ବୋଲି କୁହନ୍ତି
The cottery cannot be given the kotta. This kotta is waiting. Wait.
ମାନେ ଆମ କଟୁରୀ ମୁଁ
That means
କଟୁରୀ ଗୁଡା କେମିତି ଇଞ୍ଜୁରି ହବ ଏଇ ଯୋଉ ଷ୍ଟାବ୍ ଉଣ୍ଡ ଗୁଡାକ ଷ୍ଟାବ୍ ମାନେ ଷ୍ଟାବିଂ ଇଞ୍ଜୁରି ଗୁଡାକ ପାଇଁ ପଏଣ୍ଟେଡ୍ ୱେପନ୍ ହେଲେ ସେ ଷ୍ଟାବିଂ ହବ ଆଉ ଆପଣ ଗୋଟେ ସାଇଡ୍ ହେଲେ ତାଙ୍କୁ ମାରିଲେ ସେ କଟ୍ ଇନ୍ ନହେଲେ ଇନସାଇଡ୍ ଉଣ୍ଡ କରିବ ତାପରେ what was found in that cottery? Have you found any blood in that cottery? What is the whether it was
C report was
C report judgment of Harpu? C report was exhibit 19. Exhibit 19 does him. Iron cotton in no blood. Cutter size ଦେଖୁଛନ୍ତି
14 inch.
Page 137, 140.
ନାଇଁ opinion ଆସିଛି. The injuries over body of Sonalata Raut are possible with the weapon seized by you. IAC case. Exhibit ଅଛି ଏଠାରେ 7/1.
What is the incident?
ପୋଖରୀରୁ ଉଦ୍ଧାର କଲେ
ପମ୍ପ ସାଇଡ୍ ପାଣି ଆଣି ପମ୍ପ ଉପର ସାଇଡ୍
ସାଇଡ୍ ବୋଲି ତ କୁହନି ପୋଖରୀରୁ ଗତକାଲି ଉଦ୍ଧାର କରି ମୁମୂର୍ଷୁ ଅବସ୍ଥାରେ ଆଣି ତାହା ଦେହରୁ ଉପକ୍ତ ଜିନିଷ ଗୁଡ଼ିକ କାଢି ରଖିବା ପରେ ତାକୁ ଦେଇକି ପୁଡେଇ ଦେଇଥାଏ ଟିକେ ଓଜନ ହବ ବୋଲି ନା କଣ?
The mark is exhibit 8. One iron cutter having 14-inch length.
Right.
Handle down 5.5.
5.5 ফুট
यार length होची
14 inch.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submit that the petitioner is in judicial custody since 15/10/2014. And initially, the first information report was lost by PW2, Tiloshan Baran, who is the father of the deceased Swarnalata Raut alias Kuni alias Barsa. And the said report was lost against the in-laws family members of the deceased on the accusation that they demanded dowry and subjected the deceased to physical and mental torture. And they have also killed the deceased. The name of the petitioner does not find place in the first information report, nor he is a family member of the husband of the deceased. However, the allegation against the petitioner is that while the deceased had been to a pond on the occurrence day at about 7 to 8 p.m. PW 5 and 6 heard or shouting that the petitioner was killing or and the land council submits that PW5 Usarani Rao is none else than the accused in the first information report, and she happens to be the mother-in-law of the deceased. And PW6 is a co-village accused persons of the in-laws of the accused, in-laws of the deceased. The land council submits that though PW5 has stated that the deceased was shouting, "Pura mote mari pokauchi mote boncha," but PW6 has stated that the deceased was shouting, "Susila mote Anna mote boncha." The land council further submits that the doctor bracketed PW8 has noticed stab wounds on the body of the deceased, though it is the prosecution case that the assault was made by means of a cutlery. He further submits that the weapon of offense was found inside the sari of the deceased, and it was sent for C examination, and the C report indicates that there was no blood in the cautery. It is further argued that there are good chances of success in the case, and balance of convenience is in favor of the petitioner. And since the petitioner has remained in custody for 10 years, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail and placed the evidence of PW5, PW6, and PW8. C reporter जोटा questions for exhibit 19 per bracket. Considering the submission made by the land council for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing of the bail application, we are inclined to release the petitioner on bail allowed.
Item number 8.
May I please, my lord, on behalf of Mr. R.K. Mahanto, serial number 14/2020, copy of paper book may be served on us.
Yesterday. 14.
14/2020.
Bagunda.
Bagunda second. Beta C. What is that? Second time. বাগুন মার্ডার প্রিজনার্স পিটিশন আসছি যে রাজীব কুমার মহন্তଙ୍କ ପରିବର୍ତ୍ତରେ ଚିତ୍ତରଞ୍ଜନ ସାହୁଙ୍କୁ କେସଟି ଦେବାକୁ ଚାହୁଁ। ଆଚ୍ଛା ଆପଣଙ୍କର
14/2020 serial number.
ତା ଦେହରେ କିଛି ଆସିନି, ଏଇଟା ସିଆରଏଲ ନମ୍ବର 13 ରେ ଅଛି। So have you filed Mr. Sahu, have you filed your D number? ଦେଖନ୍ତୁ ଏଇ ଯୋଉ ସିଆରଏଲ ନମ୍ବର 13 ଟା prisoner petition has been received from the appellant, in which prayer has been made for engagement of Chittaranjan Sahu, advocate, as his counsel. He Wakalatnama or
This is the
Sahu has already filed the DNR, which is taken on the names of other counsel except Mr. Chittaranjan Sahu and his associates shall not be reflected in the positive transcript. Okay, now yeah, so far as 8 is concerned, as your first item, 14 of 2020, कौन अपन चाहते हैं?
Copy of paper book may be served on us.
On the paper book, mention is made on behalf of faster declared. Mr. Rajiv Kumar Mohanto, आपन power अच्छी?
No, my lord.
ये human को ना अच्छी कई आपन को ना की बताओ?
Officer के नाम दी.
ଆପଣ କେମିତି ଆପଣ ପେପର ବୁକ୍ ଟା ସାଇନ୍ କରି ନେବାକୁ ପଡିବ ନା
କାଲି next ଆସିଲେ ମୁଁ କହିବି.
Sure, one of the all these persons are there in your chamber or not?
Yes, in present time not there and କାଲି ଆସିଲେ
ଆପଣ ଆମେ ଅର୍ଡର କରିଦଉଛୁ ଯୋଉମାନଙ୍କର ପାୱାର ଅଛି ତାଙ୍କ ଭିତରୁ ଯିଏ ହେଲେ ଜଣେ ଆସି ସାଇନ୍ କରି ନେଇଯିବ ପେପର ହେଲା.
ଆଜ୍ଞା.
Mention is made on behalf of Mr. Rajiv Kumar Mohan that he has not received the copy of the papers. Let the office supply the copy of the paper to the Learning Council. Yes, yes, Mr. Sahu, what do you say?
Three applications there. Out of 3 I am from one.
କୋଉଟା? ଓହୋ ତା ଦେହରେ 3 ଜଣ ଅଛନ୍ତି ଏଇ ଅନ୍ୟମାନ ନାଁ ଯୋଉ କାଟିଗଲେ ସେଟା
3 ଜଣ ନାହିଁ ଗୁଡାଏ ଅଛନ୍ତି ନା ଏପ୍ଲେଣ୍ଟ ନା ଏଇଥିରେ ଏଇ ଗୋଟେରେ
13 ରେ
13 ରେ 3 ଜଣ ଅଛନ୍ତି
13 ରେ ରୁମ୍ 13 ଟା ହଁ 13 ରେ 3 ଜଣ 13 ରେ କହିଦେବୁ ଡାକିଲେ ନା ଅନ୍ୟମାନଙ୍କ ନାଁ ସେଇଟା କେବଳ ଏଇ ୟା ପାଇଁ ସେ ଆପିୟର କରୁଛନ୍ତି ଅନ୍ୟମାନଙ୍କ ନାଁ ଆସିବ ନା. What do you say? ସେଟା ସମସ୍ତଙ୍କ ପାଇଁ ଫାଇଲ ନା ୟା ପାଇଁ ଫାଇଲ ହେଇଛି? ହଁ ତ ଆପଣ ସମସ୍ତଙ୍କ ପାଇଁ କେମିତି ମୁଭ୍ କରିବେ? ତେଣୁ ୟୁ ଫାଇଲ ଏ ଫ୍ରେଶ ବେଲ୍ ଆପ୍ଲିକେସନ ହେଲା ତା ପାଇଁ ସେପାରେଟ ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ କରିଦିଅନ୍ତୁ. ତାପରେ ଏଇ ଯୋଉ IA 23 ଟା ଯୋଉଟା ପେଣ୍ଡିଂ ଅଛି ସେଟାକୁ କନଫାଇନ ହେଇଯିବ ଅନ୍ୟ ଆପେଲାଣ୍ଟ ମାନଙ୍କ ପାଇଁ ବୁଝିଲେ ନା. The Learning Council, Mr. Sahu submits that he will file a separate bail application for the appellant Bagun Munda for whom he is appearing. Put up the matter after the interim application is filed. Yes.
Oblige, my lord.
अच्छा ଆଉ ଗୋଟେ ଅଛି ଈଶ୍ୱର ମୁଣ୍ଡା ଏଇଟା କଣ ଅଛନ୍ତି ଜଗନ୍ନାଥ କାମିଲା?
Yes, ma'am.
Yes, what do you say?
Next week.
Yeah. এটা লিখদেবে জগন্নাথ কামিলারে IA number 100 for bail 6 for an adjournment କରିଦେବେ ଗୋଟେ ଡେଟ୍ ରଖିଦେବେ ଆଉ. Yes, next.
Item 9.
Regional petition ଅଛି. ଏ ତ ଦାସଙ୍କ ପାଖକୁ ଯାଇକି
ପରିବର୍ତ୍ତେ ନୂତନ ଓକିଲ ରଘୁନାଥ ଦାସ ଅଛନ୍ତି.
Well, application IA number 107/24, Lord.
107 of 24.
Yes, Lord. And appellant is in custody since 2016. 8 years.
Custody କେବେ?
30/9/16.
Under what offense you have been convicted? And
not true, my lord.
Trial court ରେ bail ନଥିଲେ?
My lord. ନାଇଁ ବେଲ୍ ମୋଟେ ନାହିଁ. ଥରଟେ ଯାଇଥିଲା ଇଣ୍ଟରିମ୍ ରେ ତାର ପାରୋଲ ସେଥିରେ ଯାଇକି ସରେଣ୍ଡର କରିଯାଇଛି. ବହୁତ ସିନ୍ସ ଲଙ୍ଗ ବେଲ୍ ନାହିଁ.
What is the prosecution case?
Prosecution paragraph 3 of the judgment are running page 4, my lord. Paragraph 2 running page 4 of the book. Here, my lord, dead body of an unknown person.
Just read paragraph 2.
Item 10.
May I please? In this case, madam, and the two appellants, one first item convicted under for life, madam, 302 case, and sub item convicted for 3 years, already more than sentence, madam. Under section 320.
Secondary bail application filing.
No, madam,
So you
324.
are to focus on this first one, JCRLA
Yes,
6
madam.
of 2020,
Madam.
right?
Yeah. Second already more than sentence he ran. 3 years.
bail
So
file
total automatically ଯିବେ ତାହେଲେ ଯାଇସାରିଥିବେ।
Madam.
जो ये JCRLA 6 of 2022 रे जणे appellant
Yes, madam.
Mansingh
Godwa.
Mansingh Godwa केबे कस्टडी गला
Custody madam 11/2/2016 madam.
11, 12.
2016. 11/2/2016. On the date of occurrence.
Wait.
YouTube trial was there.
13 12 arrest 13 forward 13/2/2016 ତାପରେ you have been found guilty under section 302
Yes, madam.
and that is the sole offense or other offensive offense?
Sole offense, madam.
ଆଉ 307 ଆଉ 324 ଯୋଉ
324
ହେଇଥିଲା
324 against the Biswanath Korba second sub item.
नो ଏଠି କମନ ଇଣ୍ଟେନସନ ଥିଲା ତ ସେଇଥିପାଇଁ କ୍ଲେମ ହେଇଥିଲା ଚାର୍ଜ ହେଇଥିଲା 307/34 302/34 324/34 ଏବଂ ସବୁଥିରେ ଆପଣଙ୍କୁ ଚାର୍ଜ କ୍ଲେମ ହେଇଥିଲା so you have not been found guilty under 307 or 324
yes ma'am
only 302 okay so what is the name of the deceased
Mansingh Godwa. This is sorry ma'am this is now Sonmati
Godwa.
Sonmati Godwa.
How the deceased is related to this?
No. As per the prosecution story, there is a civil dispute between the deceased, between the appellant and the family of the informer. After FIR allegation, he କହୁଥିଲେ ମୋର informant is the husband of the deceased. ମୋର ସ୍ତ୍ରୀ ସନମତି ଗଡ଼ବା
You come to paragraph number 2. There was a paragraph number 2. There was a land dispute.
Yes,
between him and accused Mansingh Godwa.
Yes.
5-7 line follow. All the accused persons are related to the informant. Now, at
that time, accused Mansingh Godwa being armed with a bow and arrow,
right,
and a tangia axe. The accused Vishwanath being armed with a tangia axe and knife came to his cultivable land. At the first they tried to kill the bow and Gopavandhu with the arrow, another person. But they both out of fear ran away from the spot. When informant's wife Sanamati protested the act of the accused persons, the accused Vishwanath stabbed his wife with the knife on her chest. Vishwanath Godba is second on her chest, and later Mansingh gave a blow with his axe on her neck. They also abused Sanmati in absence. Sorry, madam. They also abused Sanmati in obscene languages and assaulted her
indiscriminately
due to which she died at the spot.
So against you, the allegation is that you assaulted by means of an axe on the neck. So who are the eyewitnesses?
Eyewitnesses, madam. The informant stated
PW1,
madam.
PW1 eyewitness also. So a doctor who conducted PM?
Doctor, with PW 12, madam.
PW 12.
132 page.
Want to external injury lessons and so on so.
Part of clavicular protruding out. Left long was intact. Heart is lacerated. Upper lobe, heart, artery is torn. Fracture of left leg. Rest leg.
Eyewitness कौन कहला?
I can start with that.
Mansingh was armed with point or one tanki. Vishwanath was armed with one row. Now, just read it out. Mansingh was armed with a bow and arrow and a tangia. Vishwanath was armed with a knife and
I'm
tangia.
reading.
Mansingh
was armed with bow and arrow and a tangia. That's it. Vishwanath was armed with a knife and tangia. Mansingh armed his arrow at Gopabandhu and Debo. So they ran away from the field. My wife protested and told why they are threatening and trying to assault Gopabandhu and Debo. Accused Mansingh gave a tangia blow to her, which hit on her head, which in her
Left shoulder.
left shoulder. Accused Vishwanath stabbed my wife by knife on her chest. My wife fell down at the spot, but both the accused person assaulted her on blunt side of tangia
Indiscriminately.
Accused Vishwanath gave a blow with tangia to my sister Monica, which hit to the back of her neck. He also assaulted her by the blunt side of her tangia against her head. My sister ran away from the spot to save her life. My wife and sister both were sustained severe bleeding injury.
So how many blows the doctor detected? One injury.
One
Left clavicle region. Joki injury.
detected, madam.
PW 12 pra
Yes,
body
madam.
labiga.
Yes, madam.
Single injury on the left clavicle.
Yes, madam.
Instantaneous death जनकर.
Yes, madam. Jane.
ସେଇ ଯୋଉଟା
हाँ.
ସନମତି ଘଟଣା ଇଏ ହେଉଛି 103.
And PW 5 also Gopinath who was ran away. PW 5.
ନାଇଁ ଇଏ ପୁରା ଆଇ ୱିଟନେସ୍ ହେଲା ତାର ହଜବେଣ୍ଡ ଆଉ ଡିସିଜ୍ ହଜବେଣ୍ଡ
Due to the assault, my wife sustained 3 number of bleeding injuries on her person, like left shoulder, chest, and back.
out of vision. 7 cm, 3 cm, 5 cm, left clavicle region, and the part of clavicle protruding out. This section is swanson. Death of injuries with large vessels on the swanson and the cause right angle. So, that is real.
इनको साथ में ही सिखाना
Conviction के बोलो 302 जब चार्ज पे में इतना
307 ଆଉ
307 ଗୋଟେ 324 ରେ ବି କିନ୍ତୁ what he says man is Mansingh right is page 32 internal page re period proper to sentence convict Mansingh Garwa to undergo rigorous imprisonment for life and to pay fine of rupees 50,000 in default to suffer further I for a period of 2 years under section 3 Vishwanath ji 24 से 19 वर्ष
Yes, it's not here. Judgment is equal. 66, 65, 67.
Land counsel for the petitioner, land counsel for the state, the land counsel for the petitioner submit that the petitioner is in judicial custody since 13 to 2016. And the evidence as adduced by PW1 from the eyewitness to the occurrence indicates that there was civil dispute between the parties, and the petitioner stated to have dealt a single blow by means of an axe on the clavicle portion of the deceased, Samnamati and Godaba, which resulted in her death. And the doctor, bracket the PW12, who conducted post-mortem examination, has also noticed only one external injury on the body of the deceased, and opined that the cause of death was due to large vessels and heart. Cause of the injury was due to injury to the cause of due to the injury to the large vessels and heart. Considering the London Council for the state opposed the prayer for bail and faced the evidence of PW1 to also PW12. Considering the submission made by the Land Council for the respective parties, the nature of evidence are due, the age of the petitioner, period of tension of the petitioner in judicial custody for more than 8.5 years, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail, stay realization of fine. Here. It upon surrender certificate not yet filed. Who is the council?
Surrender certificate. Already more than sentence there on second.
Second टा पूरा कौन कहले 324 से 3 वर्ष सेटा था आपण तो इया आसीनी ना आपण बेल फाइल करना दी सेटा सेम ता संगे आसीबो now we are concerned with the item number 11 Panchanan Panigrahi, whether he was released on bail.
Surrender already surrender मिला
पड़ेला certificate का surrender
certificate file.
So you have instruction that yes sir
surrender मिला.
So you file the certificate that was the
surrender 6-11 मिला.
अरे ठीक है जी आपण फाइल कर दियंतु अप्लाई करछन surrender certificate आनी फाइल कर दियंतु कारण हमर ऑर्डर स्पेसिफिक थिला जे यू आर टू फाइल दी surrender certificate. Lekun JCRL number 108 of 2022. The London Council for the appellant submits that after availing the interim bail period, as per order dated 37/2024, the appellant has already surrendered on 6/11/2024, and he may be given some time to produce the surrender certificate. Put up this matter will be commencing from 2nd December 2020. Surrender certificates have been filed in the time. Your Chanti?
Reference में कैलकुलेट डेथ रेफरेंस
No, date reference from. Yeah,
34.
20 रे कौन करले mention करले नहीं
20. In this case, the council was now in the panel of the state panel.
Oh,
So
somebody else is to be.
she
Usarani Padi.
Padi.
She has come to the panel.
She's come to the panel.
So we have to change. That is what she was mentioning.
Mr. Human Land Council for the state, Mr. Naik, Professor Naik, Additional Hon'Ble. government advocate submit that Mrs. Usana Ani Pahi is now in the government panel. You also submission. Yes. 18 number कौन है ना?
Item 18. Item 18, my lord.
You are ready?
Yes, my lord. Appellant is convicted under such.
Eyewitness or circumstantial evidence?
Eyewitness.
Eyewitness. FIR ready place कौन?
Musri Braja Malik, Pita Bhaskar Malik.
Braja Malik.
Braja Malik the informant, my lord.
कितने नंबर से की?
Witness video number 3. थाना बालिकुदा जिला जगतसिंहपुर थाना बालिकुदा जिला जगतसिंहपुर हाजर होई एही लिखित भाବରେ ଅଣାଅଛି କି ଆଜି 10/1/2006 ସମୟ ପ୍ରାୟ 1ଟା ହେବ ମୋର
ଦୁଇଟା ହବ ନା ଏକଟା ହବ?
ଦୁଇଟା ହବ ମୋର ଭାଇ ଦିଜ ମଲ୍ଲିକ ବୟସ 45 ବର୍ଷ ଆମ ଗ୍ରାମର ବାଲାଜୀ ମଠ ହତା ଭିତରେ ଧାନ ମାପି ସାରି ଭୋଗ ଖାଇ ବିଶ୍ରାମ ନେଉଥିଲେ। ଏହି ସମୟରେ ଆମ ଗ୍ରାମର ପ୍ରଶାନ୍ତ ମଲ୍ଲିକ ପିତା ଋଷ ମଲ୍ଲିକ ତାଙ୍କ ଘରୁ ଗୋଟିଏ କୋଦାଳ ଆଣି ଭାଇଙ୍କ ମାଇଲର ପ୍ରଶାନ୍ତ ହେଲା ଆପେଲାଣ୍ଟ
ଆଉ ଦିଜ ମଲ୍ଲିକ ହେଲା
ଡିସିଜ ତାଙ୍କ ଘରୁ ଏକ କୋଦାଳ ଆଣି ଭାଇଙ୍କ ମୁଣ୍ଡକୁ 2ଟି ଚୋଟ ମାରିଲା। ମୁଁ ସେଠାରେ ବାଛୁରୀ ବାନ୍ଧୁଥିଲି। ଏହା ଦେଖି ମୁଁ ଚିତ୍କାର କରି ଏବଂ ଏହି ସମୟରେ ନବ ଦାସ, ବିକା ଦାସ, ଭାସ୍କର ମଲ୍ଲିକ ଇତ୍ୟାଦି ସେଠାରେ ପହଞ୍ଚି ଭାଇକୁ ପାଣି ଦେଲୁ। ଭାଇ ସଂଜ୍ଞା ହରାଇ ଦେଇଥିଲେ। ଗୋଟିଏ ଗାଡି ଯୋଗାଡ଼ କରି ବାଲିକୁଦା ଡାକ୍ତରଖାନାକୁ ନେଇ ଆସିଲୁ। ଡାକ୍ତରଖାନାରେ ପହଞ୍ଚିବା ପୂର୍ବରୁ ସେ ମରିଗଲେ। ପ୍ରକାଶ ଥାଉ କି ମାସକ ତଳେ ପ୍ରଶାନ୍ତ ମଲ୍ଲିକ ତାଙ୍କ ଘରୁ 200 ଟଙ୍କା ନେଇ ଆସିଥିଲା। ଆଚ୍ଛା, ତାଙ୍କ ବାପାଙ୍କ କଥା ଅନୁସାରେ ମୋର ଭାଇ ପ୍ରଶାନ୍ତକୁ 200 ଟଙ୍କା ଆଣି ତାଙ୍କ ବାପାଙ୍କୁ 100 ଟଙ୍କା ଫେରାଇଥିଲେ ହେଲା। ତାଙ୍କ ପାଖରେ 100 ଟଙ୍କା ରଖିଥିଲେ ତାପରେ ପ୍ରଶାନ୍ତକୁ ସେଇ ଟଙ୍କା ମାଗିଥିଲେ। ଅଭିଯୋଗରୁ
ଦୁଇଥର ପ୍ରଶାନ୍ତ ଭାଇଙ୍କୁ ସେ ଟଙ୍କା ମାଗିଥିଲା। ଆଜି ଭାଇଙ୍କୁ ଏକାକି ଦେଖି ଏହାର ସୁଯୋଗ ନେଇ କୋଦାଳରେ ବାଡେଇ ଚୋଟ ମାରି
ନାଇଁ ଅନ୍ୟ 3 ଜଣ ଥିଲେ ଏଟା ହୋଷ୍ଟାଇଲ ହେଇଯାଇଛନ୍ତି।
ଠିକ ଅଛି।
1, 2, 6, 8, 9, 10, 13 ହୋଷ୍ଟାଇଲ।
ଆଚ୍ଛା, ନାଇଁ ଏଇଟା ହଉଛି ଆଇ ୱିଟନେସ ହେଲା PW ବ୍ରଜମଣି। ଆଉ ଡକ୍ଟର କିଏ? PM ଡକ୍ଟର।
PM ଡକ୍ଟର।
ଆଚ୍ଛା,
ସ୍ପଟରେ
ତ ଡେଥ୍ ହେଲା।
ମେଡିକାଲ
ଯାଉଥିଲା
ଅନ୍ ଦି ୱେ।
ହଉ, ପଳେଇ ଆସନ୍ତୁ। ଆପଣଙ୍କର ପ୍ଲି ଡିନାଏଲ ପ୍ଲି।
ମାଇ ଲର୍ଡ,
Let's me come to the page number, the statement of the informant. Page number 37.
That is PW3. This one
PW3. PW3 is a brother of the deceased. In the cross examination, he stated that I am the informant in this case. I know the accused Prashant Malik. The occurrence took place about one and a half year back to the
in the month of January.
About 1 p.m. in front of the Balaji Mutt. At the relevant time, while I was tying my cow in front of the said mutter, I heard a cry from the mutter side. Hearing the cry, I came to the spot.
I rushed to
I rushed to the spot and found the
accused
Prashant Malik was assaulting the deceased Dijo Malik by
means of
spread and assaulted by, as a result, by the accused, the deceased sustained bleeding injury on the head just
above the
ear. On seeing the assault, I intervened and tried to the rescue the deceased, but the accused Prashant threatened me and assault by raising the spread. Thereafter, the local person arrived at the spot, seeing there the accused fled away,
holding
the spread and
concealed himself.
I intervened and tried to rescue the deceased, but the accused Prashant threatened to me, assaulted by raising the spade. Thereafter, the local person arrived at the spot. Seeing them, the accused fled away, holding the spade, and concealed himself inside the house. Then the deceased was shifted to Balikuda Hospital, but he was already dead before arrival at the hospital. Exhibit 1 is the affair lodging by me. Exhibit 1 by 1 is my signature therein. Police held the inquest over the dead body of the deceased in the presence of in my presence and prepared the inquest report. Exhibit 2 is the inquest report. Exhibit 2 by my signature. Cross-examination. I have not scribed the affair. It is not a fact. I have not given any statement before the police in connection with this case. It is not a fact that I have not mentioned in the affair nor stated to police that the occurrence took place about 1.5 years back in the month of January at about 1 p.m. in front of the Balaji Mutt of Oskona, and that while I was tying my cow, I heard a cry and I rushed to the spot and found the accused Prashant was assaulting Dvija by means of spade on his head, and that due to assaulting Dvija sustained bleeding injury on his head and above the ear, and that on seeing assault I intervened and tried to rescue the accused, but the accused threatened to me, assaulted by raising spade. I have not snatched the said spade from the hand of the accused. Balikuda is 12 kilometers away from the place of occurrence. The accused was shifted to hospital the deceased was shifted to hospital from the spot. I cannot say if anybody else was present in the mutt on that day prior to my arrival. My house is located at a distance of 400 yards from the place of occurrence. The deceased was not shifted to the house before shifted to hospital. I cannot say the name of the doctor who examined the deceased. It is not a fact that the accused Prashant did not assault Dvija by means of spade. I have seen only one blow given by the accused on the head of the deceased by spade, and thereafter I became unconscious. I regained my sense after 2 hours in the village. I was not treated at Balikuda hospital on that day. I have not gone to Balikuda hospital on that day. Now I do not remember if I went to my house after the regaining sense or not. I did not disclose about the occurrence to my family members. I did not inform the family members of the deceased as they came immediately to the spot getting information about the occurrence. I cannot say if the wife and children of the deceased have given their statement before the IO or not. I do not remember when the police visited the spot. I have not disclosed about the incident to any other person. It is not a fact that the allegation made in the affair are false and that being politically motivated. I have lost a false affair in connivance with the enemy of the accused. The accused has not assaulted the deceased with the handle of the spade.
ଏଇ ଯୋଉ ପୋର୍ସନ ଟା ପାରାଗ୍ରାଫ 3 ରେ
ଆଜ୍ଞା
ଯୋଉଟା ତାଙ୍କୁ କନଫ୍ରଣ୍ଟ କଲେ
ଆଜ୍ଞା
ଯେ ତମେ ଏଗୁଡାକ କିଛି କହିନ ଏଗୁଡା ତ ମ୍ୟାଟେରିଆଲ ପୋର୍ସନ
ଆଜ୍ଞା
ଏଗୁଡା ପ୍ରୁଭ କରିଛନ୍ତି ଆଇଓ ଜରିଆରେ it's not a fact that I have not mentioned in the FIR the FIR na IO statement in connection with it it's not a fact I am not mentioned in the FIR nor stated before the police so and so
I have not scribed it.
Draws to the spot and found the accused Pasham was assaulting so and so by spade on his head and due to it the FIR କହିଛି FIR ପ୍ରଶାନ୍ତ ଗୋଟେ କୋଦାଳ ଆଣି ମୋର ଭାଇର ମୁଣ୍ଡକୁ 2 ଚୋଟ ମାରିଲା ଏଟା FIR ଅଛି ଆଉ 161 ରେ ଅଛି ନା ନାହିଁ ସବୁ କନଫ୍ରଣ୍ଟ ପ୍ରୁଭ କରିଛନ୍ତି ଏ ଆଇଓ କିଏ
IO 14
14 ନମ୍ବର ସାକ୍ଷୀ ଦେଖିଲ then I will come on 161 devices ହଁ ଟୋଟାଲ ଏଇ ଯୋଉ ଆର ଏଇ ଯୋଉ ବ୍ରଜ ବ୍ରଜ ମଲ୍ଲିକ 10-300 ରେ ମୋର ବଡ ଭାଇ ବ୍ରଜ ଯେତିକି ଆମ ଗାଁର ବାହାଜି ମଠ ହତା ଭିତରେ ଧାନ ପିସାରି ଖାଇସାରି ବିଶ୍ରାମ ନେଉଥିଲା ଏଇ ସମୟରେ ଆମ ଗ୍ରାମର ପ୍ରଶାନ୍ତ ମଲ୍ଲିକ ଚାପଲାନ ତାଙ୍କ ଘରୁ ହାତରେ ଗୋଟେ କୋଦାଳ ଆଣି ଭାଇଙ୍କ ପଛ ଗୋଟେ ମୁଣ୍ଡକୁ କୋଦାଳରେ ଚୋଟ ପକେଇଲା ମୁଁ କିଛି ଦୂରରେ ବାଛୁରୀ ବାଞ୍ଛୁରିଆ ଦେଖି ମାଗୁରା ମାଗୁରା ଯିବା ପାଟି ଶୁଣି ଆସିଲେ ତାଙ୍କୁ କୋଦାଳଙ୍କୁ ଧରି ପଳେଇ ଯାଉଥିବା ସମୟରେ ଅନ୍ୟମାନେ ତାକୁ ଅଟକାଇଲେ ଗୋଟେ ଗାଳି ଖାଇଲେ ଏଟା କହିଛି ସବୁ ଆଉ
ଆଜ୍ଞା
ସବୁ ଅଛି
ବାକି ଡାକ୍ତର ବାବୁଙ୍କର ହେଲା 7 ନମ୍ବର ସାକ୍ଷୀ
ଆଜ୍ଞା page 46
page
46
dead body of the lacerated wound
lacerated out
side points and the right all the injuries of anti-mortem might have been caused weapon of offense ଟା କଣ
କୋଦାଳ
ତଳ
ଆଜ୍ଞା
ତଳ ମାନେ on decision found that hematoma was there parietal lesion
there was a fracture of parietal Extra trigger.
And operator in 10 mountain, 10 that have been
Lacerate. Fracture.
Other papers with shock and trauma resulting and bleeding injury on the head and then because of your figures and sanctions paper.
The weapon of offense was not produced with permit for remedy. I did not notice any court injury.
ସେ ଯୋଉ ମୁଣ୍ଡରେ ଯୋଉ ମାଡଟା ହେଇଛି ସେଇଟା ଜାଣ ଫ୍ରାକ୍ଚର ଇଞ୍ଜୁରି କରେଇଛି ପ୍ୟାରାଟାଇଜରେ ଆଉ ସେଇଟା ହେମାଟୋମା ତା ଦ୍ୱାରା ହେଇଛି
subcutaneous hematoma size 3 inch to 2 inch
lacerated ହେଇଛି ଯୋଉଟା କି ତାର cause of death କହୁଛି କୋମା ହେଇକି ତାର ଯାଇଛି but you know sharp side use anything which is
court engine देखने मना कला
court injury देखाएं ताମାନେ जो front side तक use कर उदाहरण
back
उदाहरण मारला ना
side back side जो iron जो
ପଛପଟେ ଯୋଉ ଏମିତି ଥାଏ
ଗୋଲ ଥାଏ ପେଣ୍ଟ ପଶିଥାଏ ଯୋଉଟା front side ରେ
ଆଣିଥିଲେ
cut
injury type ର
4 inch 5 inch
ସେ ଫଟୋ ଫିଟି ଦେଇଛି ମୁଣ୍ଡ what is your submission Mr. Mishra
In cross examination
who saki
doctor cross examination the weapon is not examined my lord of para number 5
the weapon
Doctor
of offense was not produced before me.
Yes,
not produced. My examination and opinion whether it was seized
yes
weapon da seize ହେଇଛି କି
seizure is not with me seizure is not with me
ନାଇଁ ନା ଆୟୁ କିଛି କହୁନି ଆୟୁର ଏଭିଡେନ୍ସ ପଢୁନାହାନ୍ତି
what is
ଏଗୁଡ଼ା କହୁଛି the during course of paragraph number 2 page number 60 during course of investigation I examined so and so visited the spot and seized one spade ତେଣୁ ଜବତ ହେଇଛି ସିଜର ଲିଷ୍ଟ ମଧ୍ୟ ମାର୍କ ହେଇଛି
exhibit 3
ତିନିଟା ଟିକେ ବାହାର କଲା ସେଟା ବ୍ୟାକ୍ କରିବ 6 ହଁ ଏଇଟା 3 one spade କୋଦାଳ ଲେଖା ହେଇଛି ବ୍ରାକେଟରେ ସାଇଜ ଟା ହଉଛି 7.5 ଇଞ୍ଚ ତାର ବ୍ରେଡ ଟା ସେ ଯୋଉ ଇଏଟା
Sharp side ଟା
8 ଇଞ୍ଚ ଲେନ୍ଥ ଆଉ ଯୋଉ ବାମ୍ବୁ ମେଡ୍ ହ୍ୟାଣ୍ଡେଲ ଗୋଟେ ରହିଛି ବାମ୍ବୁ ହ୍ୟାଣ୍ଡେଲ ର ଇଏଟା ହଉଛି 31 ଇଞ୍ଚ ଲେନ୍ଥ and containing blood stain of the deceased. And that spade was
human blood ଅଛି A ଅଛି
sent to the for C and A
group A
human blood form. On ଆପଣଙ୍କ submission ଅଛି
well another and I was stated that the blood group of the digger is not that were not taken that is mismatch the blood in the clothes of the appellant but that is not examined by the IO. I will stated in cross examination para number 12 blood sample disease रे से नहीं नाते step नहीं नाते पता matching करना whether the blood
disease blood matching ହେଇନି
para number 12 I have not taken the step
एवढा पूरा disease ର shirt pant ଗୁଡା ସବୁ ଏଇ ଜବତ ହେଇନି କି ଲୁଙ୍ଗି ଫୁଙ୍ଗି କାର ଏଗୁଡା ସବୁ
ତାର
ଏ ଯୋଉ
ଆୟୁ ସେ କହିଛନ୍ତି
D and D1 ଏଗୁଡା ସବୁ ତାର ପୁରା ତାକୁ ବ୍ଲଡ ଗ୍ରୁପ କରାହେଇଛି
ସେ accused of blood group named that is
accused of blood group କଣ accused
that is the description in the judgment at page 12 also After chemical examination report and report exhibit 10, the spade was sustained with deep human blood of group A origin.
Spade.
Spade.
ଆପଣଙ୍କର
Which weapon used?
Dଟା D1 ଆଉ D2 ଏ ତିନିଟା ଯାକ ହଉଛି ୟାର ଡିସିଜ୍ଡ ତିନିଟା ଯାକରୁ ମିଳୁଛି ଦିଟାରୁ ମିଳୁଛି ଆଟଲିଷ୍ଟ ଇଏ ଆଉ ତା ସହିତ ଯୋଉ ସିଟା ଯୋଉଟା ରହୁଛି ସିଟା କୁହାହଉଛି ଯେ ଏଇଟା ହଉଛି ଆକ୍ୟୁଜ୍ଡ ତା ଦ୍ୱାରା ମଧ୍ୟ ସେଠୁ ମଧ୍ୟ ଏ ଗ୍ରୁପ ମିଳୁଛି ତ ଆପଣଙ୍କର ସାର୍ଟ ରୁ ମଧ୍ୟ ଡିସିଜ୍ ର ବ୍ଲଡ ଗ୍ରୁପ ମିଳୁଛି ଏବଂ ଡିସିଜ୍ ର ସାର୍ଟ ପ୍ୟାଣ୍ଟ ଲୁଙ୍ଗିରୁ ମଧ୍ୟ ମିଳୁଛି ସେଇ ବ୍ଲଡ ଗ୍ରୁପ ଆସୁଛି ହ୍ୟୁମାନ ବ୍ଲଡ କୋଦାଳରୁ ଆସୁଛି ତା ଛଡା ଆଇ ୱିଟନେସ୍ ଅଛି ଆଉ ସୋ ଆଇ ୱିଟନେସ୍ ର evidence how do you demolish it ଆପଣ କେତେ ଗୁଡାକ କେସ୍ ଅଛି ଯଦି ଜଣେ ପାଖରେ sharp cutting weapon ଅଛି but he is using the blunt side of a sharp cutting weapon then what would be his whether it would be under section 302 or not ଏମିତି କିଛି ଡିସିସନ ଜାଣିଛନ୍ତି ପାଇଛନ୍ତି ମୁଁ sharp side ୟୁଜ କରୁନି ବ୍ଲଣ୍ଟ ସାଇଡ୍ ୟୁଜ କରୁଛି sharp weapon ର କୋଦାଳର ଯୋଉ ମୁନିଆ ପଟଟା ମୁଁ ବ୍ୟବହାର କରୁନି ତା ପଛ ପଟଟା ବ୍ୟବହାର କରୁଛି ତାହେଲେ କଣ ହବ ସେମିତି କିଛି ଡିସିସନ ସର୍ଚ୍ଚ କରିଛନ୍ତି
ଜାଣିନି
ଡିସିସନ ଦେଖିବେ କାଲି ରଖିବା
Thursday ର ଗୋଟେ ଦିନ one day
ତ ଏଇ ଅନୁପାତଟା ଟିକେ ଭାବୁଛି
if the intention part is considered
motive
ଆଉ intention କଣ intention ଟା ଦେଖିବା ଲାଗି ତ କୁହାଗଲା
motive ଟା
ହିଣ୍ଟ ଦିଆଯାଉ କେମିତି ଦିଆ ହବ ତ
There is no use front side. Means
the blank side of the open was having a sharp putting time here, but he used the blank side, not this. It point came home. Partition of our more.
that's open.
Open, हाँ, set of click. On empty board, that. वो ये साइड रो हाफ साइड रो आसी वो ये एपटे डिस्टन बाहरिबो अरे एगुडा कवर करछि देखियो केम दिया जाय
अरे ये टाइप से कौन दे दीजिए तो हाँ ये तो नहीं
एडिशन बाहर करो प्रिंट आउट बाहर पूरा दीजिए हाँ ये देखियो नहीं अभी तो पढ़ा पढ़ी तो करना भी सब
Relying on the Ram Asera plus state of UP lordship judgment that there in Odisha our High Court.
we have only few
Okay.
maybe last month or something
JCRL 8 of 2010
Makru Naik versus State of Odisha
Makruna JCRL 8 of 2010
and
there the intention and motive that
decision में rely करते थे point रे यादरे मध्य injury देखंतु हमें एटा sharp cutting weapon use ହେଇଥିଲା we have mentioned what are the injuries that they are all also lacerated wounds
part 1 itla 02 part 1
para 10 now the question crops up for consideration whether the surrounding substance with the crimes has been committed in ingredient such and such. It appears that even the record that there was a good relation item.
Supreme Court decision orako both AC
1990.
The Honorable Supreme Court held that it cannot can be reasonably inferred that such assailant had no intention to cause
intention and motive
otherwise there was no reason to use the backside of the bunkas instead of which in normal courts would have caused the death of so and so. Again, another decision, the Supreme Court decision like if the appellant had intention to commit a Gondasi Martala. It was held at so and so. Harish Kumar so and so. It has been Tapure conclusion asila.
Conviction of the appellant is altered. Para 11, section 30 IPC 230 part 1.
8 view रे order नहीं
The ban is नहीं take pounds. ये का हार पे ना paragraph long side decision बाहर कर दिया
print out कर दिया
এটা রিপোর্ট है ये पढ़ो हाँ
मैं रिपोर्ट करूँ नहीं थोड़ा
देखिलो उसी अभी 7 मन है अगस्त छड़ दिया
अगस्त सितंबर
नवंबर सितंबर देखियो सितंबर अक्टूबर देखें एम पूजा मकरू नायक इंडेक्स को बढ़ाया ଏଠି ଆଉ କହିଲେନି unnecessary ଗୋଟେ ପ୍ରିଣ୍ଟ ବାହାର କର ନଭେମ୍ବରକୁ ଯାଉନି କି ଡିସେମ୍ବର ଦେଖିବ ମାନେ ଏଇ ମାସରେ ବାହାରି ସେମାନେ ଦେଖିଛନ୍ତି ଆମେ ଏଇଠି
para 11%.
କେତେ ବର୍ଷ ହେଲାଣି
2006
6 ଅଛି 18 ବର୍ଷ
18 ବର୍ଷ ହେଲାଣି. Here is the case. That case your lordship 2008. The judgment is
Mr. Swanson. ସତ୍ୟନାରାୟଣ ଆପଣ କିଛି ନମ୍ବର ଫମ୍ବର ଅଛି କି ଆଉ ଜଣେ ତାଙ୍କର ନମ୍ବର 4 ବୋଲି ସେ କହନ୍ତି ତ ଇଏ ହେଲା S.A.C. Who judgment is trying to written for taking the sectors like that. You can be something to note for the note for the approve my state of Orissa. 2024-96
এবার এই হচ্ছে এই
নভেম্বর
Pardon, my lord.
Item surrender certificate 2026.
26 ଟା ରଖିଦେଇଥାନ୍ତୁ କିନ୍ତୁ ହିୟରିଂ ଲିଷ୍ଟ ଅଛି ଆଉ ତାଙ୍କୁ ରଖିବାକୁ ଆକ୍ସେପ୍ଟ କରି ଲେଖିଦିଅନ୍ତୁ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଫାଇଲ ନୋଟିଂ ପ୍ରୋସେସ
My lord, my item is 51, my lord. One of the juvenile is there, my lord. He is in custody, my lord, more than 8 years, my lord. 51, my lord. 4 appellant is there, my lord. In this 4, my lord, one is juvenile, my lord, at the time of incident. But the
it is life conviction.
Life conviction, my lord. Already honorable court, my lord justice D.DASH court, my lord, call for the school certificate from the school. Already he is already in the file, my lord.
but that is already decided.
No, after this bench will change, my lord.
No, that inquiry has to be conducted.
Yeah.
Already completed, my
That
lord.
report has come.
Yes, already
Report is in your favor.
Yes, is in my favor. He is in juvenile at the time of incident, my lord. One of the accused, only one of the accused, Bhairav Mahant, my lord.
So what about the others?
Other are, my lord, direct, there is no direct witness, so-called witness.
appeal file ହେଇଛି
My lord,
ଏଟା କେତେ ଜଣ ଫାଇଲ କରିଛନ୍ତି
4 ଜଣ ଅଛନ୍ତି ଏଥିରେ।
ତ ଆମେ ଯେତେବେଳେ ଜଜମେଣ୍ଟ ଟା ଦବୁ ମାନେ ଆକୁ ସେଗ୍ରିଗେଟ କରିଦବୁ ତା ପାଇଁ ତାପରେ ରଖିଦବୁ ନା ପିଲା ଡିସାଇଡ ହବ ନା ସମସ୍ତଙ୍କ ପାଇଁ ତ ସମସ୍ତଙ୍କ ପାଇଁ ଆପଣ ତାଙ୍କୁ ଦିଅନ୍ତୁ ସେ ଲେଟିଂ ଗେଟ୍ ପ୍ରିପେୟାର୍ଡ ଏଇଟାକୁ ପ୍ରିପେୟାର ହୁଅନ୍ତୁ ସେ କୋଉଟା କଣ ଆଇଟମ କରୁଛନ୍ତି
51
ଆଇଟମ ନମ୍ବର 51 ବୁକରେ ହେଇଯାଇଛି ତ
ହଁ ପେପର ବୁକ୍ ହେଇଛି।
କୋଉଠି ରିପୋର୍ଟଟା କୋଉଠି ଆସିଛି କାହିଁ ଲେଖା ହେଇନି ତା ଦେହରେ ଗୋଟେ ଯାଇଥିଲା ସେ ଜୁଭେନାଇଲ କି କଣ ତାର ରିପୋର୍ଟଟା ମଗେଇବାକୁ ଦେଖିଦେବେ ରିପୋର୍ଟଟା ଆସିଛି ନାହିଁ ଯଦି ଆସିଛି ଷ୍ଟେଟ କାଉନସିଲକୁ କପି ଦେବେ and that is so get those decision
yes, I have collect some decision also.
State council को भी दे दियो है ना तो that this point can be raised number 1 at any time that is also there in the statute
Yes,
And number two, if that is the juvenile, then what will happen? So, say that they don't let him study.
Yes,
Report has seen, I suppose the report are after that at the time of occurrence, he was a juvenile. Put a particular idea. The report of happened. तो कालिका पाई गोटे आइटम रेडी करंतु एटारे काली बोधे रेडी हे परिबेनी जो नेक्स्ट वीक रे नवा बट रिपोर्ट टा नै जातो से कोते रिपोर्ट अछि तो
रिपोर्ट मु फाइल देखि
फाइल अछि विल बी सप्लाइड
Okay.